The Clerk will now proceed to read the orders of the day.
Renters Reform Bill, as amended in the Public Bill Committee, to be considered.
Now, we begin with Government New Clause 15, with which it will be convenient to debate the other selected new clauses, amendments and new schedule as listed on the selection paper. I call Minister Jacob Young to move Government New Clause 15.
Thank you, Madam Deputy Speaker. And I beg to move New Clause 15 and the other amendments in my name. I'm delighted to bring the Renters Reform Bill back to this House for report stage, and I'd like to express my gratitude to members across this House for their contributions to the bill during second reading and committee stage, and for their continued engagement throughout. I'd like to start by thanking my predecessors, my honourable friend, the member for Walsall North, who I had the privilege of being the PPS for as he steered the White Paper, and my honourable friend, the member for Redditch, who I had the privilege of being the whip for as she steered second reading. And I've seen this bill at every stage of its formation, and I can say to the House, the bill we are discussing today would not have been possible without their hard work and dedication. I'd also like to pay tribute to the Honourable Member for Woolwich and Greenwich and the Honourable Member for North Shropshire for their constructive engagement and their commitment to see this bill delivered so its benefits can be realised. Madam Deputy Speaker, the Renters Reform Bill will create a fairer private rented sector for both landlords and tenants, delivering the Government's 2019 manifesto commitment. The bill brings in the most significant reforms for the sector in over 30 years. The bill will abolish Section 21 and bring in new decency standards, giving England's 11 million tenants more certainty of secure and healthy homes. It will mean tenants will be supported to hold down jobs in their local area, children to stay in the same school, and households to put down roots in their communities. And alongside abolishing Section 21, we're also strengthening and expanding landlord possession grounds, including stronger protections against antisocial behaviour. This, combined with our reforms to ensure a modern court system, will ensure that landlords retain confidence in getting back their properties when they need to, safeguarding their investment. The new private rented sector ombudsman will resolve tenants' disputes and support landlords in handling complaints effectively. This will help avoid disagreements escalating unnecessarily to the courts, saving both landlords and tenants time and money. And our new property portal will also make landlords' responsibilities clear in one place and support tenants to make more informed choices. We're also providing stronger protections for renters with pets, recognising the joy that pets can bring. And Madam Deputy Speaker, this bill must strike the balance between delivering that security for tenants and fairness to landlords.
Way, the Secretary of State this morning had the brass neck to suggest that keeping his promise to outlaw no-fault evictions before the next election is now apparently down to the House of Lords to get on with it. Can the Minister tell us which is most disingenuous? Is it the 5 years we've been waiting for this government to keep their promise? Or is it the blatant concessions to the significant numbers of Conservative MPs sitting behind him who are landlords who've been gifted what amounts to an indefinite delay to ban no-fault evictions?
Madam Deputy Speaker, as I said earlier on, we introduced the White Paper in 2022. We published this bill just last year in 2023, and we're bringing forward this bill today to abolish Section 21. She talks about members on my side. I can tell her, and she won't read this in the newspapers, I've been lobbied not just by members on my side, but by members from all sides of this House on making sure that these reforms work effectively. That's what the changes that we're making today at report stage do. They bring balance to the bill, delivering security for tenants, and as I've already said, fairness for landlords. These amendments ensure the new tenancy system works effectively.
The Minister for giving way, but since the government promised the outlaw Section 21 in 2019, over 2,000 people have been evicted as a result of no-fault eviction, costing the council millions of pounds to rehouse these people. So when he talks about fairness for landlords, does he realise the cost to renters, but also the local authorities in the cost of temporary accommodation?
Thank you, Madam Deputy Speaker. I absolutely accept that there's a cost to that. What I'd say to her is a system that doesn't work for landlords will not benefit tenants. And a system that doesn't benefit tenants won't benefit landlords in the long run either. We have to find a balance in this bill, and that's what our amendments today deliver. As I was saying, the amendments we introduced at committee stage include expanding the range of factors a judge must consider when evicting antisocial tenants, providing stronger protections for landlords and neighbourhoods against unacceptable behaviour. We also added a new ground for possession to protect the functioning of the student market and ensure that student landlords can continue to evict in line with the academic year. Turning to housing quality, while the vast majority of landlords provide warm and decent homes, there are some who fall short of this standard. It's unacceptable for any tenant to live in damp, cold or dangerous housing. For this reason, we introduced measures at Commons Committee to apply and enforce a decent home standard to the private rented sector for the first time. This new standard, which we're designing with landlord and tenant groups, will be set out in secondary legislation. We also introduced measures to outlaw deeply unfair blanket bans on renting to those with children or those in receipt of benefits. In both England and Wales, these practices have no place in a fair and modern housing market. And of course, I give way.
Given way. Just in terms of the decent home standard, will he give an assurance that there will be proper energy efficiency standards contained in that decent homes standard? Otherwise, tenants will still be living in damp and cold homes because they can't afford to heat them.
Madam Deputy Speaker, I can commit to working with the Chair of the Select Committee and all members of this House on making sure that the decent home standard does provide for decent homes of the kind that he describes. As I've already said, this is the first time we're applying the decent home standard to the private rented sector. We have to get this right. Finally, to target the minority of unscrupulous landlords, we gave stronger powers to local councils and strengthened rent repayment orders. This will help ensure effective and proportionate enforcement of the new system. Now, I'll turn to the government's amendments that we're introducing today at report stage. They respond to concerns from members, from constituents, and tenant and landlord groups, ensuring security for tenants whilst giving confidence to good landlords and supporting the private rented market. With that in mind, I'd like to acknowledge several members across the House who have played a direct role in helping us make sure the bill works as effectively as possible for all those who live and work in the private rented sector. That, of course, includes my honourable friend, the member for Totnes, and the honourable member for Northampton South, for their continued engagement and constructive dialogue on the measures in this bill.
Giving way, but I'm listening to him carefully. You wouldn't think from his contributions that there was any controversy at all about the position we've now got to with the government's introduction of this legislation. If everything is so wonderful, why is it that all of the key housing charities and organisations in the field have withdrawn their support for the government?
Thank you, Madam Deputy Speaker. I'd say to the Honourable Lady, they haven't withdrawn their support. I accept their disappointment in some of the measures that we're bringing forward today, but they've also endorsed some of the amendments we're bringing forward today, including one that I know is very close to her heart around expanding the homelessness prevention duty, which has the support of organisations like Crisis, the homelessness charity, and will continue to work with everyone across the sector to make sure this bill is effective as it goes to the other place as well. But as I say, Madam Deputy Speaker, turning to these amendments, I will address each of them thematically. Starting with our tenancy reform measures. Government New Clause 15 will ensure a tenant's notice to quit cannot expire within the first 6 months of the tenancy unless the landlord has agreed it can expire sooner. This increases the amount of time a tenant must remain in a property at the start of a tenancy from 2 to 6 months. This change ensures that landlords are able to recover the costs of replacing tenants, and it will prevent tenants from using PRS properties as short-term or holiday lets. Once the initial 6-month period of commitment has ended, the tenancy will then continue as a normal periodic tenancy. And so after the 6-month period, tenants will only need to give 2 months' notice. This ensures tenants will still retain the flexibility to end tenancies when their circumstances change or a landlord doesn't fulfil their responsibilities. This strikes the right balance of providing landlords with confidence that they need to operate within the PRS while ensuring a fairer, simpler tenancy system. In addition, Madam Deputy Speaker, the Government's exploring potential exemptions to this, such as the death of a tenant or domestic abuse or significant hazards within the property. And today I met with the Domestic Abuse Housing Alliance to reaffirm our intention on the exemption and make clear that victims of domestic violence will be better protected by these reforms. Government Amendments 239 and 240, which I've just mentioned to the Honourable Lady, will give tenants certainty that homelessness prevention duty will be owed when a valid Section 8 notice is served. And I'd like to pay particular tribute to the Honourable Member for Harrow East for his contributions on this, ensuring his landmark Homelessness Reduction Act continues to be effective. The prevention duty will apply where the date specified in the notice is within 56 days, and the duty may not be ended simply because the 56 days has passed. This will mean that households can continue to receive support while the threat of homelessness remains. Mindful that this will broaden the scope of the prevention duty, we'll carry out a new burdens assessment and will provide funding for local authorities for any additional costs. Alongside expanding the homelessness prevention duty, I'd like to take this opportunity to restate our position on another important issue. The Statutory Homelessness Code of Guidance, which local authorities must have regard to, states that authorities should not consider it reasonable for a homeless applicant to remain in the property until a court issues a bailiff warrant or writ to enforce a possession order. We've heard anecdotal evidence that some local authorities are encouraging tenants on a blanket basis to remain in a property until the bailiffs are at the door. That is wrong. Doing so creates further delays in possession, penalises landlords who have a legal right to their property, and can be stressful and in the long run, not beneficial at all to the tenant. The guidance is clear on the importance of early prevention. Authorities should contact landlords at an early stage to understand the circumstances of an eviction and establish what steps can be taken to prevent homelessness. Government is also working to ensure that families can move out of temporary accommodation and into stable accommodation, as well as reducing the need for temporary accommodation by preventing homelessness before it occurs in the first place. That's why the Government is investing over £1.2 billion in the Homelessness Prevention Grant over the next 3 years, including £109 million top-up for the Homelessness Prevention Grant for 24-25. This is part of an unprecedented £2.4 billion to tackle homelessness and rough sleeping. It's expected, furthermore, the £1.2 billion local housing fund enables councils in England to obtain better quality temporary accommodation for those owed a homelessness duty, providing a lasting, affordable asset. It's expected to provide around 7,000 homes by 2026 to ease local homelessness pressures, reducing spending on unsuitable B&B accommodation, and provide safe, sustainable housing for local communities. Government Amendments 64 to 75 extend the restriction on reletting and marketing a property following the use of the moving in and selling grounds to cover licences to occupy as well as tenancies. This will mean that landlords and people acting on their behalf, like letting agents, will be prohibited from letting or marketing a property as a short-term or holiday let following the use of these grounds. And I'd like to thank my honourable friend, the member for North Devon, as well as the member for North Shropshire, who raised this in committee. This change closes a loophole in the no reletting period and helps ensure that the balance between long-term and shorter-term lets remains stable. I'll now turn to government amendments to the possession grant, starting with the student market. And I know this is an issue close to my honourable friend, the member for Loughborough's heart. As I said, at Commons Committee, the government introduced a new ground for evicting full-time students to maintain the yearly churn of student housing. However, since introducing that ground, we've heard concerns that the ground would not apply when students are living in smaller properties or in houses of multiple occupation on individual contracts. Government Amendments 226 to 228 expand the circumstances in which the student ground can be used. Landlords will be able to ensure that properties rented to students, whether they're living individually, in pairs, or in larger shared housing, will be vacated in the summer as long as all of the tenants on the tenancy agreement are students. To protect tenants, we've strengthened the requirement for landlords to provide notice to the tenant at the outset of the tenancy that the ground may be used to evict them. Possession will not be possible using this ground unless written notice has been given by the landlord at the beginning of the tenancy. Turning to Government Amendment 158, this will extend Ground 1B to allow social landlords to re-let their property to a different tenant on rent-to-buy terms, protecting the supply of these properties. This ground will only be available after the sitting tenant's discounted rent period has ended and they have been offered the chance to purchase the property. And I'd like to thank the National Housing Federation for raising this issue. Government Amendments 175 and 184 insert a new possession ground, Ground 5H, into Schedule 2 of the Housing Act 1988. This will allow private registered providers of social housing and charities to continue to operate schemes sometimes known as stepping stone accommodation. We're keen to support these schemes, which help those who've struggled to access the private rented sector, and I'm grateful to Centrepoint, as well as the Mayor of the West Midlands, Andy Street, for drawing this to my attention and for all that he's doing to support organisations like these. Government Amendments 198 and 199 and New Clause 29 serve to replicate an existing mechanism that allows landlords of qualifying agricultural workers to provide assured short-hold tenancies rather than more secure assured agricultural occupancies. This amendment was the main ask of the Country Land and Business Association and is vital to maintain the supply of homes for rural workers by protecting the status quo. It will ensure that opted-out agricultural occupancies under the old system will continue to be opted out when they transition to the new tenancy system. Leaseholders have raised the issue that many leaseholder agreements restrict subletting on assured short-hold and fixed-term tenancies. Amendments, including Government Amendments 160 to 164 and New Clause 13, will address this ask by ensuring that subleases made under these agreements can continue unabated under the new tenancy system, and new agreements can be made if they were previously permitted. We've drafted these provisions very carefully to ensure that superior landlords and leaseholders have corresponding rights and responsibilities as they did under the previous system. Turning to Government Amendments, New Clauses 18 to 24, these extend the provisions to outlaw blanket bans on letting to tenants in receipt of benefits or with children to Scotland in consultation with the Scottish Government. They do so in a broadly similar way to those in England and Wales, with adjustments to align with the Scottish enforcement framework, demonstrating a cross-nation commitment to tackling discrimination in the private rented sector. Now to Part 2 of the bill. We've made technical amendments to our redress clauses, including ensuring that the PRS Landlord Ombudsman can cooperate with other dispute resolution services. These will ensure the Ombudsman operates effectively. Now, while no final decision on the Ombudsman provider has been made, our amendments would also allow the Housing Ombudsman Service to effectively administer private landlord redress alongside social redress. A key driver in having a single ombudsman to resolve private landlord-tenant disputes is to make the service simple to use. And I want to reiterate to members that the Government is absolutely committed to minimising costs and streamlining new requirements for landlords. Our ambition is for fees for the PRS Landlord Ombudsman to be low cost and value for money for landlords, similar to that of the Housing Ombudsman, where membership costs for social landlords were just £5.75 per unit in the year 23-24. I'd also like to reaffirm our commitment to aligning the Ombudsman and Property Portal, with the ambition being that landlords will only need to input their details once to be compliant with both services. Turning to enforcement of the new system, we introduced measures at committee stage to ensure all landlords involved in criminal rent-to-rent arrangements can be held to account, including superior landlords where they're aware of illegal activity. Government New Clause 32 ensures that superior landlords are liable for the Housing Act 2004 offences of failing to hold the correct licence for a property. And Government New Clause 33 seeks to ensure that both landlords and superior landlords can, where appropriate, be served with improvement notices requiring the removal of hazards. These changes close loopholes, ensuring local councils can continue to hold the correct landlord to account for ensuring their properties are safe and well managed. But clearly, it's important that superior landlords who could not have reasonably known that the property was being let as a house of multiple occupation are protected against being penalised for the failure to licence. Government New Clause 32 provides additional defences to make sure that's the case. Indeed, as is already the case, the criminal standard of proof would need to be met for any landlord to be convicted of or subject to a fine or rent repayment order for such an offence. And finally, I'll talk through the measures we are adding to the bill to make sure it is effectively implemented. And again, I'd like to acknowledge the contributions of other members given voice by my honourable friend, the member for Totnes, so that these reforms deliver for all and avoid unintended consequences. We've been clear that Section 21 will be abolished when we're confident that the county court system is ready, and we're taking significant steps to ensure this. We've already invested £1.2 million for the Courts and Tribunal Service to deliver a new end-to-end online possession process. The Government accepts that we need to assess the operation of the county court possession process as we deliver our tenancy reforms. An efficient court system is critical to ensuring confidence in the new tenancy system. Government New Clause 30 therefore requires the Lord Chancellor to prepare an assessment of the operation of possession proceedings for rented properties and for this to be published before Section 21 can be abolished for existing tenancies.
If the government are putting all this money in and doing all this planning, why can he still not give us a date as to when this is actually going to happen?
Thank you, Madam Deputy Speaker. Well, as I have just said, we've always been clear that we will abolish Section 21 when we're confident the county court system is ready. I can't give him a date today because I can't say it until we're confident that the county court system is ready. But as I've already said, we're investing £1.2 million for the Courts and Tribunal Service to deliver this new processes. And I think it's important that the Honourable Gentleman recognises that a court system, if we don't have a ready court system, when we make this change, the biggest change in 30 years, if the courts aren't ready for these changes, that will not benefit tenants. It won't benefit landlords, but it certainly won't benefit tenants either. Now, Government Amendment, New Clause 30.
So I welcome the amendment in New Clause 30 because the reality is the county courts are already under very great pressure indeed. But carrying out the assessment will of itself bring a cost. And of course, Ministry of Justice budgets are themselves already strained. What steps are going to be taken to pick up the cost and to support the Ministry of Justice and Lord Chancellor in the costs of carrying out that important assessment?
Well, I'm grateful to my right honourable friend, and he is absolutely right. We've committed to doing this assessment, and therefore we will ensure that the relevant funding is in place. As I've already said, we've already invested £1.2 million for the Courts and Tribunal Service to deliver a new end-to-end online possession process. But I'm pleased to also confirm today to my honourable friend that we're investing a further £11 million this financial year to deliver a new digital system as well.
The past have tried to blame the Select Committee for this delay by saying that we noted there was a problem in the courts and the courts would need to be ready to deal with the extra work caused by the abolition of Section 21. But the government's had 5 years to actually sort the courts out and get them working properly. Surely this has been planned for right from the last election. And I'll just point out, in terms of the Select Committee asking for improvements in the court, the Select Committee asked for a specialist housing court, a bit like a small claims court that could have processed things more quickly. We didn't ask for it last year in our report, we asked for it in 2018, and the government rejected it.
Thank you, Madam Deputy Speaker. Well, I think I've been quite clear that it is important that we see the courts ready for these reforms. The honourable member for Finchley is on the front bench here with me, the Minister for the courts, and I know that he and the MOJ are working at pace to ensure that the courts are ready for the reforms that we're introducing. He asked about a specialist housing court. We don't believe that this is the best way to improve the court process for possession, a view shared by the judiciary who responded to our call for evidence.
On this point, the chair of the Select Committee quite rightly points out that he said that this should happen 5 years ago. I would just gently say, though, that in those 5 years we have had the coronavirus, and that has been the main thing slowing down the process of improving the courts. And again, I strongly encourage the Minister not to be rushed into doing this prematurely, because it will not benefit tenants and it will not benefit landlords either.
Thank you, Madam Deputy Speaker. I don't think it will surprise you to learn that I entirely agree with my honourable friend, and I thank him for making those points. As I said, Government New Clause 30 will enable the Government to assess the effect that our new tenancy system is having on the county courts before our reforms are rolled out more widely, giving us confidence that the sector is ready. And I'm also happy to share with colleagues that we're exploring whether serious eviction cases, such as antisocial behaviour, can be prioritised in court listings as we consult on options following royal, and we will consult on options following royal assent. Turning to Government New Clause 35, this requires the Government to...
Can I thank you? Just on New Clause 30, I recently met with Rent Start, which is a homelessness organisation with a great track record of working with landlords and getting the homeless into rented accommodation. They're slightly concerned about the changes in the sense that they may undermine their relationship with landlords, which they use to facilitate finding homes for many vulnerable constituents or other people that have come into the constituency. Just in relation to the assessment that New Clause 30 will bring about, what reassurance can he give those organisations?
Thank you, Madam Deputy Speaker, and I'm grateful to my right honourable friend. I would say that the assessment is purely there to determine the timeliness of possession proceedings. But I think in addition we also have to acknowledge that there are other barriers to possession as well, such as the role of local authorities and the role of the bailiffs in that process as well. And I hope that that's what the assessment is able to draw out. When it comes to Rent Start in his constituency, I don't believe our reforms will affect the relationship that they have with landlords, but I'm more than happy to meet with him and Rent Start to understand their concerns more clearly and see if there's anything we can do to address that. Turning to Government New Clause 35, this requires the Government to arrange for a review of the new tenancy system, in particular the impact of removing fixed terms and the operation of grounds for possession. This review will be carried out by an independent person who will produce a report of their findings. The amendment requires the Government to lay the report before Parliament within 18 months of the earliest date that the new tenancy system is applied to existing tenancies. We recognise that removing fixed terms is a significant change for the sector, and this review will explicitly consider the impact of this change. It will also consider how comprehensive and fair the reformed grounds for possession are, as well as the extent to which they're operating effectively, so that all parties can have confidence in them. As I've said, the new tenancy system is a huge change for the sector, the biggest in 30 years, and it's right that we commit in legislation to reviewing its impact and its implementation and consider if changes are needed, based on real-world evidence. This will ensure the system works as well as possible for all parties for the long term.
I thank him for giving way. I mentioned several times during the debate, and the Honourable Member for Kensington is here because we had a very useful meeting with her, that there is a necessity to also amend the Protection from Eviction Act 1977 at the same time, because the danger is that sort of frustrated rogue landlords will refer back to that law and that legislation, which is very badly understood and not well enforced by police and local authorities. Can he perhaps just mention a few things about that, if he can at all?
Well, Madam Deputy Speaker, I'm more than happy to address those points before the end of the debate, but I think I wrote to the Honourable Lady on these points, and if not, I'll make sure that I have, to be clear, in respect of the amendment that she's tabled. Government New Clause 36 places a duty on the Secretary of State to produce and lay an annual report before Parliament on the stock of residential tenancies in the private rented sector. This will need to be provided in the 5 years after the bill gets royal assent. Reports under this duty will cover, but not limited to, an analysis of the number, location and size of private rented sector properties. This amendment ensures that regular analysis of such information is available for scrutiny and debate. I'm also aware that several members have raised concerns relating to the interaction between the property portal and the role of selective licensing. The two systems have separate, distinct purposes. The portal will gather data on the private rented sector, ownership and property standards in England. It will provide an information source for local authorities to have oversight of the whole private rented sector in their area. It will help landlords understand their legal obligations and will give tenants the information that they need to make informed choices. Selective licensing provides local housing authorities with the powers to license privately rented properties within a designated area to address specific local issues, including poor housing conditions, high levels of antisocial behaviour or crime. Whilst there will be overlap with data gathered for the portal, information required for licences in these areas will be specific to the issue being tackled and will support more intensive enforcement action in areas that need it most. We do not want to see selective licensing abolished, but we do want to ensure that our reforms are streamlined and that burdens are minimised for landlords and local authorities. That's why I'm committing to a review of selective licensing and licensing of houses of multiple occupation to consider how we can reduce burdens and make the system more effective for landlords, tenants and local authorities. And I'm keen to work closely with members and the wider sector on this, and will provide further details in due course. Madam Deputy Speaker, I have sat on many bill committees in this House. I was privileged to lead my first bill committee facing the honourable gentleman opposite, who's been a great person to work with and has sought at every opportunity to make sure this bill works and is effective. And as I said to him in committee, we would listen to how we can improve this bill, and we are doing so today. For tenants, we're expanding the homelessness prevention ground and closing loopholes in the system. For landlords, we're introducing an initial 6-month tenancy and giving them certainty that our reforms will work. This bill delivers on our manifesto commitments, it gives tenants security and landlords fairness. Our amendments continue in that balance, and I commend them to the House.
Notices to quit by tenants under assured tenancies. Timing.
The question is that new clause 15 be read a second time. Before I call the Shadow Minister, I just want to remind colleagues that if they wish to intervene on a speech, it is important that they've been there at the beginning of the speech, just in case the important point that they wish to raise has already been addressed, and that they stay for the duration of that speech in case others then refer to the important point that they have raised. Just to clarify that, because we may have a longer speech from the Shadow Minister and people may wish to intervene. So I thought it's helpful to remind colleagues of the rules on that. Shadow Minister Matthew Pennycook.
Thank you, Madam Deputy Speaker. I rise on behalf of the opposition to speak to the new clauses and amendments in my name. It is a pleasure to finally be back in the Chamber to conclude the remaining stages of this important piece of legislation. I say finally, Madam Deputy Speaker, because, as you all know, the bill left committee on the 28th of November last year, almost 5 months ago. Indeed, such has been the delay in bringing it back to the House that in the intervening 147 days, the Department even managed to complete the entire common stages of another piece of housing legislation, albeit a distinctly limited and unambitious one in the form of the Leasehold and Freehold Reform Bill. The reason for the delay is, of course, an open secret. With the ongoing resistance to the legislation from scores of honourable members on the government benches, including many with relevant interests, as private renters across the country have certainly noted, and the undignified wrangling between them and ministers splashed across the papers for months. The damage that has been caused as a result of the discord on the government benches is significant. Not only have thousands of additional private renters been put at risk of homelessness as a result of being served a Section 21 notice in the months the bill's remaining stages have been delayed, but the sector as a whole has been left in limbo, not knowing whether or not the bill will proceed at all, and if so, in what form. Indeed, such has been the frustration at the impact on landlords and tenants of the endless rumour, speculation and off-the-record briefings that have taken place that two organisations, as different in their outlook as Crisis and the National Residential Landlord Association, felt compelled to come together to issue a joint statement pleading with the government to bring the destabilising and damaging lack of progress and uncertainty to an end. Well, it has now finally been brought to an end, Madam Deputy Speaker. Not with ministers summoning the courage to face down their unruly backbenchers, as they could have, with the votes of these benches if required, but as is par for the course with this weak and divided Conservative government, with a series of concessions designed to placate those backbenchers at the expense of private renters who will see a number of the rights and protections initially provided for by the bill watered down. The very fact that the government are now suggesting that the bill requires further significant amendment is ironic, Madam Deputy Speaker, given that the argument that the Parliamentary Under Secretary repeatedly drew on in committee, as he resisted 81 Labour amendments, was that as originally drafted, the bill struck precisely the right balance between the interests of landlords and those of tenants. And yet he's been put in the undignified position today of having to come to the dispatch box to ask the House to accept in good faith that conversations with Conservative backbenchers in the wake of committee stage have convinced the government, in all sincerity, that more amendments are now essential to ensure that balance is kept. It is, frankly, laughable, Madam Deputy Speaker, and the reality of the grubby political horse trading that has taken place within the government is entirely transparent. The truth is that the only balance the government have ever sought to strike when it comes to this bill is between attempting to honour the letter of the 2019 Conservative Party manifesto commitment and appeasing the vested interests pressing for the very minimum amount of reform required to assert that it has been met. Before I turn to the detail of the amendments before us, let me briefly set out Labour's position on the bill as we consider its remaining stages. With the government having promised private renters it would scrap Section 21 no-fault evictions over 5 years ago, we maintain that this legislation is shamefully overdue. Given that any further delay would cause yet more harm, both to private tenants who are desperately in need of greater rights and protections, and to responsible landlords who above all else require certainty, we believe that as imperfect as it is essential that the bill completes its passage today. Because it still contains, despite our best efforts in committee, numerous defects, deficiencies, omissions and loopholes that would allow the minority of disreputable landlords to exploit tenants and jeopardise their security of tenure, we remain firmly of the view that the bill is not yet fit for purpose and that it must be strengthened to the benefit of renters. As a result of the fact that the government appear determined to do the opposite and further tilt the playing field toward the landlord interest, we're determined not only to continue to press for those changes that we argued for in committee, but also to oppose those government amendments that are detrimental to the interests of private tenants and that jeopardise the integrity of the bill as introduced and risk fatally undermining it as a result. With the former objective in mind, I turn first to the amendments and new clauses we have tabled for consideration this afternoon. Nearly all are identical to the ones we pressed in committee, and they aim, among other things, to increase the minimum notice period in respect of de facto no-fault possession grounds from 2 to 4 months, to remove the punitive and draconian new ground 8A relating to repeated rent arrears, to better protect renters against unreasonable within-tenancy rent increases, to allow the tribunal to make rent repayment orders for additional specific breaches, to prohibit rental bidding wars, to extend Awab's law to the private rented sector, and to maintain the existing Ground 14 definition of antisocial behaviour, rather than the government's expansive new definition of being, quote, capable of causing annoyance or nuisance. And I commend each of them to the House. Madam Deputy Speaker, of particular importance to us is the need to ensure that Section 21 evictions are definitively abolished at the point the bill becomes law. As drafted, the legislation provides for a two-stage commencement process for the introduction of the new tenancy regime, with precise dates for new and existing tenancies to transition determined by the Secretary of State. We made clear in committee that we believe this two-stage transition process is the right approach, given that it would clearly not be sensible to enact the whole of Chapter 1 of Part 1 of the bill immediately at royal assent. However, we argue that landlords and tenants should be given certainty about precisely when the government's manifesto commitment to abolish Section 21 no-fault evictions will be enacted. In resisting our efforts in committee to amend the bill so that Section 21 is repealed on the day the Act is formally approved, the Minister argued, as the government have consistently done since announcing the concession in their response of the 20th of October 2023 to the Select Committee, that it would be wrong to do so until the courts are ready. The problem is, Madam Deputy Speaker, that the government has never been able to clearly articulate precisely what ready in that context means. Indeed, after weeks of debate in committee, what ministers believe the necessary court improvements encompass and what criteria will be used to determine whether sufficient progress has been achieved remains entirely ambiguous. Honourable members may recall that the background briefing note that accompanied the King's speech suggested that required improvements relate only to the court possession action process. In contrast, the government's response to the Select Committee last year outlined a far more expansive list of, quote, target areas for improvement that included many elements of the wider package of court reforms alluded to in the White Paper. We had hoped that the Minister might bring some clarity to the matter at committee stage, yet in response to forensic questioning from honourable members about exactly how the government believes the county court system is underperforming, what is the precise nature of the improvements that it believes are required before Section 21 is completely abolished, and how progress on delivering those improvements will be measured, the honourable gentleman unfortunately offered little more than vague comments about ongoing digitisation, action to tackle bailiff delays and end-to-end processes. As a result, as we contemplate sending this bill to the other place today, not only do renters still have no idea when the new tenancy system will come into force, but they remain entirely in the dark on what might constitute the requisite progress in respect of court reform that ministers have deemed necessary before it does. In our view, such a degree of uncertainty is simply unacceptable. The end of no-fault evictions cannot be made dependent on an unspecified degree of future progress in respect of court improvements subjectively determined by ministers. And let's be clear, Madam Deputy Speaker, I will give way.
He's making an interesting point about uncertainty, and I understand where he's coming from, and there are many of us on this side who'd very much like to see Section 21 implemented as soon as possible. But does he accept that there is the other uncertainty, which is if there is a court system which isn't working adequately, the effect on the amount of private housing stock that is available for many of our constituents who need it badly could easily shrink fast, as indeed I believe has happened in Scotland, and that would be a much greater risk than not laying out at this stage the precise date at which Section 21 will be fully implemented.
I'd say two things to the honourable gentleman, and it's a valid point. Firstly, the government have had 5 years since they first made the commitment to abolish Section 21 to get the courts fit for purpose, and they haven't done so. Indeed, the timescales for both possession and litigation have remained essentially unchanged since 2019, so no progress in those 5 years. The actual process of possession proceedings is also probably one of the more efficient aspects of the county court system. And we heard extensive evidence in committee about the fact that the system is essentially working fairly well, recovering well from COVID, and that these changes would not be significant enough to delay the implementation. But even if that were the case, what I would say to the honourable gentleman is, let's have clarity about precisely what those improvements the government thinks are necessary are. Let's have metrics, let's have timelines, and then we can have an open and transparent conversation about precisely what ready means. At the moment, we are entirely in the dark. And Madam Deputy Speaker, we will remain in the dark because even if Government New Clause 30 were to be incorporated into the bill, because that amendment would merely require the Lord Chancellor to publish an assessment of the operation of the County Court Possession Order process in England and its enforcement before the extended application date could be set for Chapter 1 of Part 1 of the bill. There's no timescale in which that required assessment needs to be published. There's nothing that specifies the metrics the Lord Chancellor would judge the readiness of the court system against. There are no corresponding obligations imposed on the Secretary of State. So if a future Lord Chancellor assesses that funding or other specific measures are required to make the courts ready for the new system, there's nothing to compel the government of the day to implement them. And even if a future Lord Chancellor were to assess that the courts were more than ready, it remains for the Secretary of State to determine whether they wish to make the relevant commencement order, even if Clause 116 is amended by Government New Clauses 27 and 28. In short, I will give way.
Like my honourable friend, I understand where the honourable gentleman is coming from, and I don't have a problem with the abolition of Section 21, no-fault evictions. But as a South East London MP, he will know the reality is that the county courts face enormous pressure, particularly in our part of the world, and I hope, before honourable members criticise the government too much, they'll perhaps talk to their own local county courts, because we are in a situation where the data is suggesting that on average you could be looking at about 55 weeks for commencement of a possession claim till the decision is made, then on top of that you have enforcement. Now that's not acceptable. I want it to be quicker, but we do need, therefore, to accept as the Association of District Judges have said, and those are the data which the Justice Select Committee has got the most accurate, I have to say to people, that we have to be realistic about the situation in. Because the District Judges Association points out that there has been underfunding of the County Court for many years, and frankly, under governments of both parties, because I can remember when I was in practice, when the Honourable Gentleman's government was in party, and there was underfunding of the county courts then as well. We all have to take our share of responsibility for that, rather than making that a matter of party controversy.
Right, Honourable Gentleman, for that point. We all want the processes to be quicker. I don't think that's in dispute at all. And they certainly could be made quicker. Landlords need robust grounds for possessions in legitimate circumstances, and they need the system to be able to operate quickly when they do. The question for us today is, should we essentially put the abolition of Section 21 on hold until we have reassurance about an undefined amount of improvement that we don't know when that is going to be delivered? I will give way.
I thank the Honourable Member for giving way. It is, I mean, all I've heard is about the importance of ensuring that the courts are functioning quick enough to enable landlords to evict the tenants they want. But currently, renters only have a month, just over a month before they are evicted. I had a constituent who had lost his son in the most horrific of circumstances, and he was in the local papers. The family was served Section 21 notice, whilst the landlord knew the family had lost their child. They said they had to serve it because they had a month still. They needed to get them. So where is the protection for the renters? And does he agree with me that the kicking of the Section 21 notice abolition that into the grass means they really don't care about renters at all?
Well, I think my honourable friend is right to highlight the impact on renters. And that's essentially what we're debating here. Every month that passes, more private renters are served Section 21 notices. Nearly 85,000 of them have been put at risk of homelessness as a result of being served one of those notices, as the government has delayed the implementation of its commitment. And as the bill is drafted, even as I said with Government New Clause 30, we have a situation where the Minister can determine whenever they want to signal to the House that the courts are ready. We've got no assurances on that point, and we don't think that is satisfactory. And Government New Clause 30 in particular, Madam Deputy Speaker, in our view, is nothing more than a mechanism designed to facilitate the further delay of the complete abolition of Section 21 evictions, and we will look to vote against it. With the government having previously made clear that there will be a requirement for 6 months advance notice before new tenancies are converted, and a minimum of 12 months between that conversion and the transition of existing tenancies, with the proposal today that the latter also be made subject to the assessment required by Government New Clause 30, it could well be years, Madam Deputy Speaker, before renters see Section 21 completely abolished, making a complete mockery of the Secretary of State's recent claim that such notices will be, and I quote, outlawed by the next general election. And we know the government are in no rush to abolish Section 21 evictions because they're not laying the groundwork that is necessary for that to happen. Where are the draft prescribed forms for Section 8 notices? Where are the proposed amended court forms and civil procedure rules? There's no sign of them, Madam Deputy Speaker, or any sense of what the regulations required to bring them forward might be. Because the truth is that ministers determined long ago, for reasons that are entirely obvious, to essentially kick the can down the road on Section 21 while disingenuously denying they are doing so, taking the passage of this bill as a signal that they've been abolished. Well, private renters outside of this chamber will know they have not been abolished by the point of the next election, and that the implementation has been pushed back potentially indefinitely. We believe that hard-pressed renters have waited long enough for the commitment made by the Conservatives over 5 years ago to be delivered. They require certainty that it will truly be honoured and Section 21 evictions definitively abolished with the passing of this legislation. Our Amendment 28 would provide that certainty by ensuring that Section 21 of the Housing Act 1988 is repealed on the day that the bill receives royal assent, with saving provisions for any notices served before that date, so they remain valid and of lawful effect. I commend it to the House. Madam Deputy Speaker, Government New Clauses 27, 28 and 30, to which I've made reference, are of course only 3 of the 225 government amendments that were tabled just before the deadline last week. Before concluding, I want to touch briefly on several of the more substantive among them, starting with the small number that would be genuine improvements to the bill. We're pleased that the Government has responded to our calls to ensure the maintenance of a number of the regulatory obligations which have built up around Section 21 notices over the years by tabling Government New Clause 14 that gives the Secretary of State the power by regulation to transpose those preconditions and requirements into Section 8 eviction notices. Similarly, we're pleased that the Government have listened to the argument made by my honourable friend, the member for Weaver Vale in committee, and through Government Amendment 239 will amend the bill to ensure that tenants maintain the right to access homelessness support when served with a valid Section 8 notice. Sadly, Madam Deputy Speaker, these and other sensible Government amendments to the bill, including new clauses 32 and 34, are overshadowed by others that are far more concerning. Chief among them is Government New Clause 15. As the Minister has explained in his remarks, this amendment would prevent renters from serving a notice to quit within the first 4 months of a tenancy. Coupled with the 2-month notice period provided for by the bill as introduced, it would mean that tenants would be unable to leave a property until they had resided in it for at least 6 months, unless the landlord agrees otherwise. The Government have committed to considering exemptions to this fixed initial 6-month letting period in serious circumstances such as domestic abuse, the death of a tenant, or if a serious hazard is present in the property. But there's nothing in the Government amendment as drafted to guarantee that any such exemptions will ultimately be made or what they would look like in practice. And even if such exemptions were introduced, we believe the proposed 6-month initial period would still be extremely damaging. Not only would placing the onus on tenants to prove that they qualify for an exemption under serious circumstances deter many, particularly those experiencing domestic abuse, from exploring such an option, but a fixed initial period of any kind risks fatally undermining the integrity of the new tenancy regime itself. Premised as it is, Madam Deputy Speaker, on all future assured tenancies being periodic and open-ended, with tenants able to end their tenancy when they see fit with appropriate notice as provided for by the bill. Now, the Government have advanced 2 arguments in justifying the 11th hour introduction of their new Clause 15. First, that it will ensure that the costs borne by landlords of finding tenants and making repairs between tenancies are covered. Second, that it would prevent tenants using rented properties as short-term lets. Yet all the available evidence suggests that the prohibitive costs of moving are leading tenants as a whole to stay longer in their homes, and there is no evidence whatsoever to support the entirely hypothetical notion that tenants en masse are likely to game the new tenancy regime in order to use rental properties as short-term lets. The truth is, Madam Deputy Speaker, there is no compelling rationale for Government New Clause 15, and as the Minister knows full well, if the Government were not having to appease a small minority in their own ranks, they would not be proposing it. We believe that the proposed 6-month initial period will not only trap large numbers of tenants in unsafe and unsuitable properties, but that it puts at risk the coherence of the tenancy regime that is at the heart of the bill, and we will look to vote against it. In conclusion, Madam Deputy Speaker, this is a long overdue piece of legislation, and it is imperative. There's no question that it needs to progress today. But for those of us on these benches, the bill as introduced was only ever a starting point for overhauling the regulation of the private rented sector. As it progressed, it should have been enhanced so that the playing field between landlord and tenant was levelled decisively. Instead, the fractious state of the Conservative Party has seen the Government make concession after concession in an attempt, and it is a fruitless attempt from what we can see, to placate a minority of honourable members on the Government benches. We need to draw a line today on what that minority is able to extract from ministers to the detriment of private renters who deserve better, and strengthen the bill in a number of important respects. And I urge the House to come together to do so.
Tim Loughton.
Thank you, Madam Deputy Speaker. There are many amendments on which I could speak. Indeed, the book of amendments seems to be almost as long, if not longer, than the bill itself. But I'm going to limit myself to the new clause 12, which I have put forward in my name and those of honourable friends and colleagues, on which amendments 44, 45, 46 and 47 are contingent. Essentially, Madam Deputy Speaker, the purpose of this amendment, and I should first of all declare an interest in the Register as Chair of a Safeguarding and Quality Board for a children's company, because that goes to the heart of my interest, because this deals with care-experienced children. Essentially, the purpose of this amendment is to ensure that landlords do not discriminate against people who've grown up in the care system when making the decision on who to rent the property to, and it would place a specific duty on them, preventing them from denying those who've grown up in the care system a tenancy on that basis. And landlords who are found to be in breach of the newly inserted clause could be subject to penalties. That's the thrust of what I'm trying to achieve, and I think that may strike a chord with many colleagues here. And some may remember a recent case which really highlighted the potential problem there is here, where the Guinness Housing Trust, in advertising a property for rent, specifically said that it was not available to care leavers. That was an extraordinary piece of discrimination, redolent of the bad old days where people put up signs saying no dogs, no Irish and no blacks, if we can remember back that far. And here there was a potential discrimination against young people who, through no fault of their own, happened to have been through the care system. Guinness fortunately withdrew that straight away and apologised, but it did reinforce the vulnerabilities that there are for some of the most vulnerable young people in our society when trying to get onto the basic of daily requirements, a roof over their heads. So that's what's behind this amendment today. And I want to thank a coalition of various charities and organisations who have done a lot of the heavy lifting on this, led by Bernardo's and the charity for care experienced young people, Become, as well as others. Now, let me say at the outset, Madam Deputy Speaker, that this is a probing amendment, and I'm grateful for the positive engagement that I've had from the Minister already, and I'm wholly optimistic he's going to say some helpful and constructive things when he comes to respond. So I just really want to flesh out why I think this is an important amendment in this important bill, where there are many other priorities as well, I fully admit. So I have, as you know, Madam Deputy Speaker, a very long-standing care and interest in championing care experienced young people, formerly as Children's Minister, and I currently chair the All-Party Group for Children and Vice Chair of the All-Party Group for Children in Care. So why do we need to do more to support care leavers when accessing accommodation in the private rented sector? And I think it's imperative, first of all, for us to consider the bigger picture in terms of the issues faced by our young people leaving care especially. There are over 85,000 children and young people currently in the care system in England. It's a recent high, and every year over 12,000 of them leave that care system. And we all know, unfortunately, despite all the best efforts and endeavours of successive governments and ministers, that care leavers still have much poorer outcomes than their peers. They're less likely to gain good qualifications in the education system. Nearly half of children in the care system have a mental health problem, and it's estimated that a quarter of homeless people have been in care at some point in their lives, and they're also disproportionately represented in the justice system, and over a quarter of serving prisoners. So from the age of 18, care-experienced young people are often expected to be financially independent and manage their own household bills. But research over many decades has shown that care leavers are much more financially vulnerable than their peers, and a significant number live on or near the poverty line and struggle to make ends meet. And we all know, unfortunately, despite all the... While I'm being echoed, Madam Deputy Speaker, while inflation is now beginning to, as if you can't get enough of me once, you're now getting it in stereo with a time delay. Whilst inflation is now beginning to come down, there are certain sectors that continue to see large price increases, which of course includes the private rented sector. Private rental prices paid by tenants in the UK rose by some 6.2% in the 12 months to January of this year, unchanged for the second consecutive month. And that puts a huge pressure on all tenants. But for young care leavers living independently at the age of just 18, they have no support from the bank of mum and dad, and for them things can be especially tough. I will, of course.
I thank the man for giving way, and he's making a very important and very excellent point about care leavers. Isn't one of the problems that on reaching the age of 18, they're deemed to be able to be independent? They have no support network in the way that other young people of 18 often do, and therefore, whilst they're getting a housing support, are not getting the necessary emotional and advice support that all other 18-year-olds get and obviously benefit from. And isn't there a need for some sort of arrangement to ensure there is a continual level of support well after the age of 18 if the individual young person actually wants it?
Well, I agree with the Right Honourable Gentleman up to an extent, and of course young people don't magically become much more sustainable and resilient after the day after their 18th birthday. But there have been many improvements over the years. Extended support for care leavers up to the age of 25, arrangements where they still can have a relationship, including a financial relationship with foster carers, for example, the Staying Put scheme that the government has come up with, the very good work that many charities and organisations do to provide support. But the point he makes is right, that whereas those of us lucky enough to be able to go running back home to birth families for help and support in difficult times is not always available to those children in the care system, although many do have the continual support of good quality foster carers and other carers that they've relied on when they were under the age of 18. But they are vulnerable. So ensuring that these young people have a safe and stable home to start their adult lives is really crucial. Housing can act as a vehicle for stability, and without access to good quality accommodation, young people will face challenges in getting a job, participating in education and ongoing training, accessing health services and everything else. However, despite the key role that housing can play in helping a young person transitioning to independent living, many care leavers are struggling to find suitable accommodation in those early years after leaving care. And it's estimated that 1 in 3 care leavers, Madam Deputy Speaker, becomes homeless in the first 2 years immediately after they leave care. And 1 in 4 homeless people have been in care at some point in their lives, as I mentioned earlier. Now, there are many barriers that young care leavers face in accessing appropriate accommodation, and many of them will not be able to be addressed within the context of this bill. However, what the bill does offer is an opportunity to address one of those barriers, that landlords sometimes feel reluctant to rent to young people who have grown up in the care system. Young people in care tell charitable organisations in the youth sector that they do come across landlords that are reluctant to rent to them because of their circumstances. And evidence from a survey of care leavers carried out by the charity Centrepoint found that over 1 in 10, in fact 13%, said that they'd been unable to access accommodation because the landlord was unwilling to accommodate them because of their status. That's not fair. And the problem is also likely to get worse, given the growing evidence of a reduction in the number of private rental properties available to rent across England. And one investigation by the BBC found that the number of properties available to rent across the whole of the UK had fallen by a third in the 18 months up to March 2023. And increased competition for the properties which are available has enabled more landlords to pick and choose which tenants they like, often go for the highest bidder, and that, of course, makes it especially challenging for vulnerable groups such as care leavers. Now, Madam Deputy Speaker, for the last few years, Bernardo's has been running a campaign to try to improve access to suitable accommodation for care leavers. This is a campaign that I certainly support, and it calls on all local authorities to offer rent, guarantor and deposit schemes for care leavers seeking to rent in the private rented sector. The McAllister report on children's social care, which the government commissioned, which published last year, made a recommendation that care-experienced children should be a protected characteristic. And I have to say that so far, I think in excess of 60 local authorities, including my own in West Sussex, have voluntarily acknowledged that, although the government hasn't made it a statutory addition at this stage. So some local authorities are already providing help to care leavers with deposits or a scheme where they can act as a corporate guarantor. And such schemes really help make care experienced young people more attractive tenants, and a number of local authorities report that such schemes have had significant successes. The scheme operated by Kent County Council, for example, had no defaults in rent from when the scheme started in 2018 until 2021. However, such schemes are not offered by most local authorities. And a Freedom of Information request by the Care Leaver Offer website to the 151 local authorities in England with a children's social care department showed that 60% will not act as a guarantor for care leavers. Now, I understand that Bernardo is currently in conversations with the Department for Education to discuss how these schemes can be extended, with more local authorities encouraged to develop them. And this is welcome. However, while such schemes will help, they'll not be successful if landlords continue to have a reluctance to rent to this group and pass them over in favour of younger professionals who can offer the backing of a family or a personal guarantor or higher incomes on their own terms. So that's why I'm urging the Minister, with this amendment, to extend the provisions in the bill to require landlords not to discriminate against certain groups of tenants to care leavers. And young people who've grown up in care have often faced very difficult circumstances in their lives, which is why they've ended up in care. And when they come into care of the state, we agreed that we would become their corporate parent. And I very much see this amendment as being a key to fulfilling this duty and providing important extra support to care leavers, ensuring more of them will be able to access a safe and stable accommodation that they can call home. In closing, Madam Deputy Speaker, can I also say that I think there's a basis for having a consideration for foster families as well. Again, from my experience working with fostering groups, there can be reluctance by landlords to rent to foster families who have a number of children who will change and may be a little more problematic in some cases as well. And yet foster families do an essential job. We are short of about 8,000 or 9,000 foster carers in this country, and the last thing we need is for them to not be able to offer a safe, stable, loving home to a child who's been through traumatic experiences because they can't get into rented accommodation themselves because landlords don't want to be housing children who may be a little more challenging in some circumstances, but in most cases not. So I think there needs to be consideration as well that landlords should regard foster caring families as actually people that should be encouraged because they are doing a noble and worthy job for vulnerable children. And that's just the sorts of tenant, frankly, they should want to encourage as well. So perhaps in considering the way we treat care leavers themselves going out into the big wide world to rent, we should also be mindful of the needs of foster carers who've done such a fantastic job in picking those children and young people up and guiding them through until adulthood. So I want to secure the Minister's commitment to work with colleagues, particularly at the Department for Education, who has the lead responsibility for children in the care system, to consider how to involve landlords when developing new rent guarantor and deposit schemes for care leavers, and to agree to keep the issue under review with a possibility of using the power that the Secretary of State has within the bill to extend the non-discrimination clauses to groups such as children with care experience. So I know my honourable friend is sympathetic to the thrust of this. It is a probing amendment, but I think we need to send out a very clear sign in his response and the government's official response to this, that discriminating against children in the care system and care leavers is not on, and instead people have more of a duty of care to do everything they can to make sure those young people who've missed out on many of the things that we take for granted, a safe, loving family at home, aren't disadvantaged yet again by not being able to get a roof over their head. And I hope the Minister will respond, as I'm sure he will, favourably to this probing amendment.
Before I call the next speaker, just to inform the House that I will be giving priority to those members who've got amendments down so they can move them before we move on to others. Chair of the Select Committee, Clive Betts.
Thank you, Madam Deputy Speaker. I think it's a disappointing day that we're having to focus primarily on the government backpedalling on the timetable for the abolition of Section 21. The Select Committee looked at this a year ago, and we concluded unanimously that the principle of what the government intended was right. We obviously had some reservations and caveats, some suggested detailed changes, some concerns that we raised, but nevertheless the principle was agreed. And I think, generally speaking, there is agreement across the House. It's the right thing to do. But in the meantime, and the reason we thought it was the right thing to do, there are people living in uncertainty in private rented housing. That's what this measure is for, is to give greater certainty to people that they know where they'll be living in a year's time. Not merely that, but they know if they're going to get to work in the morning and haven't got a car, that they can get on the bus where they live to their place of work, and they have to move home because the landlord evicts them. Will they be able to get to that job in the future? Or the child's at school, or children at school, will that child, those children, be able to get to the same school if they're evicted from their home and have to find a new property? It's that sort of family certainty the abolition of Section 21 will introduce. And in the meantime, there will be so many families living in uncertainty, not just housing uncertainty, but other uncertainties, while the abolition is awaited. And that's why the Minister really needs to get on with this and give some clear time commitments to when this is going to happen. We've just discussed the problem in the courts. Yeah, of course, COVID's affected a lot of public services, but I'd just say to the Minister, it's not a surprise. If you go back pre-COVID and you go and look at how long it was taking local authorities to get court hearings to deal with antisocial behaviour cases, they had run into months, even then, before COVID. This has been a problem in the courts for many, many years. And that's why we suggested as a committee, and suggested before, a housing court system. I know that ministers don't want it, the Justice Department doesn't want it, but it seemed to us a way of resolving problems which are often very simple, very quick. A small claims court format could do it, without, in many cases, the need for lawyers to be introduced. I'm sorry, I just have no conviction that with several months looking at and several years contemplating and plans for action, the courts are going to be any quicker in 2 or 3 years' time than they are now. I'm sorry, I just think the court system has got delays and it's likely to remain. Therefore, we need to look a bit beyond the existing court system to resolve these problems. Obviously, ministers have set their mind against it. Just in terms of the other main problem that we highlighted, in terms of implementation, is local authorities and local authority staff. We know local authorities are desperately short of staff in the private rented sector for enforcement. Once Section 21 goes, tenants who are currently frightened to make complaints against their landlord, even when they're living in appalling damp properties, because they're concerned the landlord will evict them as soon as they make a complaint, will now feel emboldened to make the complaint, and if the complaint isn't listened to, will be emboldened to go to their local authority and ask for help. Local authorities are going to get more requests for help, and they haven't got the people to deal with it. So, will the Minister now assure us that he is starting to talk to the Local Government Association about the new burdens that will be placed on local authorities? It is a new burden, a good new burden that we imposed on them, and that there's some agreement on the resource that will be needed, because resources don't produce extra staff overnight, and local authorities are going to need that advance warning to make sure we've got the staff in place to be able to respond quickly as soon. Of course I will, yes.
I was for interrupting the honourable gentleman, but given the important point that he is making about redress for tenants and who they might go to, I just wonder whether or not he would add any comment on the consumer protection for unfair trading, which is one of the remedies for those who have got difficulties with either the standard and quality of their property, or indeed with the landlord, or indeed having been missold a property for a rental period.
Yeah, I think the reality is that local authorities are generally short of resources right through, as our recent report on local authority funding from the Select Committee, again unanimously agreed, showed. And very often, because of the demands of social care on local authority budgets, other services are being cut even more than the mainstream. And yes, so we've looked in the past, trading standards, consumer protection are an important element as well. So in the new burdens discussions, I would hope they would also be factored in. Absolutely right. So in terms of just one or two things I think the Minister could resolve fairly quickly. He referred to the important role the Ombudsman can play in resolving disputes. Sometimes there's a bit of a conflict between whether someone goes to the Ombudsman or goes to the courts. Sometimes the Ombudsman won't deal with a case if it's in the courts. I think those issues would be helpful to clarify. But why doesn't he just make a decision that the Housing Ombudsman, currently dealing with social housing issues, is going to deal with private sector housing issues as well? Just make the decision. Because again, if the Ombudsman is going to have that responsibility, they need to gear up and start recruiting more staff and get resources in to be able to do it. It's a simple decision. He hasn't ruled this out, but he hasn't ruled it in. Can we just do it? It seems the obvious thing. Why set up another body that will have to start from scratch when the Ombudsman's got the skills to do it? Slightly different skills in some cases, but just let them get on with it and tell them now they're going to have that job to do. Just a couple of other points. The issue of the property portal, I think that's actually a really, really welcome development, a positive move. Very often now we know that when you're trying to track down a landlord, often the local authority to serve a notice on them, suddenly the ownership of the property moves and a different member of the family becomes an owner or a different company is set up. To actually know who owns the property, and that information has to be given in the property portal, along with all other information about the property, is a really important step forward. And to make sure that the portals are digitised so they can be kept up to date very easily and simply. I welcome what the Minister said about the fact that selective licensing and property portals are not the same thing. The property portals are going to be there for all properties. Selective licensing by the name are there for some properties. I just want to be assured by the Minister that when this review happens of selective licensing and the relationship with the property portal, will those proposals come back to this House for consideration at some point? Because many of us do support selective licensing. We see them operating against the worst landlords in the worst properties, and we hope that there won't be a diminution of those powers and responsibilities to weaken what selective licensing can achieve. Yes, Minister.
Certainly make a commitment to working with him and his committee when we are at the point of making a decision on where we go after such a review, because I completely agree with him. Selective licensing has its role. It's not overtaken by the property portal, but we have to make sure the two work together.
Helpful assurance from the Minister, which I accept, and I think he's already given assurance on terms of the Decent Home Standard that similar collaboration will happen there as well, and that's appreciated. Finally, Madam Speaker, I come to some amendments I've moved specifically, and they are complicated. They even confuse me on occasions, I have to admit, because of the difficulties. They're around the powers that social landlords have when they come to regenerate areas. We've heard on the committee some pretty awful examples of poor properties in the social housing sector, and we've been very critical of it. We recognise, however, that often it isn't an individual property that's a problem. It's properties in blocks, in deck access blocks, sometimes built 1960s, 70s or 80s, where you've got to the point where the property's really reached the end of its life. It's damp, it's got other problems, people don't like living there, there's antisocial behaviour, the management costs are high, and the regeneration, the costs of making those properties fit for purpose, bringing them up to a decent home standards, are so great that they're not worth the money spending on them. So there is a need in some cases for demolition and rebuild. In other cases, there's a need for substantial regeneration and improvement of those properties. But to do it, you've actually got the tenants to move out. And social landlords in those cases need to be certain that they have the power to require tenants to move, because if you go to a block of properties with 100 residents in, you probably get 95 of them terribly enthusiastic about moving out, particularly if they're going to get a new, better home or a refurbished home. But the other few may dig in and stick it out and can hold the whole of the scheme up. Now, the Minister believes that the social landlords still have the power to do that under existing legislation. I've moved some amendments, 52 onwards, and related amendments on the order paper. What the National Housing Federation are concerned about is that they think they have powers, but those powers don't exist where the initial tenancy they have with their secure tenant was set up by a nomination from a local authority. Now, it's a complicated legal issue, but an important one. I think they're also concerned that if they're moving someone on to another secure tenancy and you're giving a tenant, taking a tenancy away, a secure tenancy, and giving a secure tenancy in return, then you could probably move someone on in those circumstances. But if you're moving someone on to not a secure tenancy because it's a decamp property, pending their home being refurbished, then they may not have the same powers. So I think there are just complications around here which are legal and technical. What I'm saying to them is I'm not going to move these amendments today, but I put them down because the NatFed are still concerned, even with the Minister's assurance about this. So just the Minister, would he agree to meet with myself and the National Housing Federation to try and make sure that they do have the powers to act in this way, which I think everyone will support them doing?
Those are all very legitimate points, and I'm more than happy to meet with him and the National Housing Federation.
For giving way. And on that collaborative point, for responding that way, Minister, for responding that way, and on that collaborative point of agreement, I'll end my contribution, Madam Deputy Speaker.
Natalie Elphicke.
Thank you, Madam Deputy Speaker. I'm very pleased to follow the chair of the Housing Community Select Committee on which I sit, and I think he expressed very well the importance of these Section 21 reforms, in particular to families and to renters who are so reliant on them. It is my view that this bill does not go far enough now in dealing with the fundamental challenges of the private rented sector. The private rented sector is no longer a flex or transitionary tenure. It is the main tenure for millions of people for much, if not all, of their lives. There has been a long-term structural shift away from social renting and home ownership and into this expanded private rented sector, and that shift needs to be addressed through building more homes, affordable and first-time buyers, but also in finding that new balance that reflects this new reality for millions of people in our country. Sadly, the original principle of the bill, which was to create a fair and responsible new rented sector, has been undermined by the government's amendments. This change of position undermines not just the bill, but the very manifesto commitment on which the Conservative government was elected in 2019. Turning specifically to the amendments in my name, New Clause 39 on relocation payments would require a landlord to make a relocation payment to the tenant if the tenant is evicted within 2 years of the start of the tenancy, other than on exempted grounds, such as for antisocial or criminal behaviour. Evidence from Shelter and Generation Rent is that unrecoverable costs, that's the cost, the wasted cost to the renter from an unwanted move, can be between £700 and £1,700. So New Clause 39 proposes that a payment is to be made by the landlord in recognition of these unrecoverable costs to the tenant. Being evicted places a great emotional strain on tenants who find themselves in insecure housing situations. It should not place them under a financial strain as well. Turning to Amendment 257, this would amend Ground 12. This is possession due to a failure to carry out an obligation of the tenancy. It's contained in Schedule 2 of the Housing Act 1988, setting out the grounds for possession. This is a provision which will gain much greater importance with these changes, for it is the catch-all provision now for evictions. Amendment 257 is intended to address the risk of being served a notice for eviction for trivial matters, such as hanging up your washing outside, or displaying a poster on the wall, or your teenager putting one up, a poster that is, with blue tack. These are real examples written into existing tenancy agreements by letting agencies who are members of their relevant professional bodies. Amendment 257 would provide that Ground 12 could only be used for material breaches, not for blue tack. Now, the Minister has written to me saying that there were landlords who wanted to make the Ground 12 position mandatory. These are landlords who want to be able to serve notice and evict tenants for using blue tack. In my book, if you are to lose your home, it should be for a serious reason, not for blue tack or hanging out the washing outside or any other trivial thing. All the more so because we know that the majority of evictions take place when notices are given to the tenant without court applications, let alone court repossession orders. Now, the Law Society has raised the issue of the scarcity of legal advice available to tenants across the country. And already in this debate today, we have heard that the government has not yet produced even working drafts of what the new forms might be for the new eviction grounds. And that also matters because the court forms at the moment just require the ground to be set out in the document. They do not require, for example, for that to specify whether it is in fact a discretionary or other ground for the courts. So this does impact directly on the tenant's understanding and ability of whether and how to challenge their potential eviction. As such, the government's position at the moment to allow Ground 12, the blue tack ground, unamended, is to invite every landlord to invoke spurious and unfair reasons for evictions. This is apparently not the intent of the bill, and I'm grateful to the Minister for his engagement with me on this ground. And I would ask him if he could consider this position again and see what more can be done to make sure that Ground 12 only applies in serious issue matters. This seems much more reasonable and fair to landlords and tenants alike. Now, turning to the government's new Clause 30. When I spoke to major landlords recently, they confirmed to me that they are not yet ready to digitise. They are not yet ready to put in place and work with the very provisions that they have so strongly advocated to the government. I understand that it might take some more than 2 years to put their own systems in place to engage with these new measures that they have asked for. And meanwhile, and after all of this time, nearly 5 years, the government has no detailed plans about what these court changes might be. Now, at committee stage in November, the Minister denied that this was a delaying tactic. However, since then, the Ministry of Justice has published its digitisation and reform programme all the way through to 2025. There is absolutely no reference, not even an indicative reference, to this reform programme relating to repossessions. And I've asked for assistance from the House of Commons Library, and they too haven't been able to assist me in finding any specific reference to these changes which may come up in the court process. So I'm afraid the truth is that new Clause 30 is a delaying tactic to benefit landlords. As has been mentioned, the Housing and Community Select Committee has written to the Minister in relation to the implementation of these measures. It has been noted by the committee that there is already court guidance in place to deal with repossession claims in a timely manner, and these are contained already in Civil Procedure Rules 55.5. Now, of course, the courts can always be improved, and indeed it is most welcome that there is a commitment that they should be so. But it should be noted that the Ministry of Justice's data shows that last year the target that has been set out for repossession has in fact been met. The court's performance in landlord repossession cases stands in marked contrast in the recovery since COVID to many other court backlogs. And this was confirmed in written evidence to the Justice Committee. And I'm grateful to my right honourable friend the chair of the Select Committee, who's not currently in his place, but for whom I have the greatest respect. But I do note that in the written evidence to his committee, the Ministry of Justice just in December confirmed that 95% of courts were meeting this target. And I understand that the much longer level of weeks that he may have referred to may relate to personal injury and other matters that were brought before that committee, but I will discuss this with him, as I appreciate that he is not in his place at this present time. So these are important reforms, and it is important that the court processes work in the right way. But it is also the case that the court processes are working within their current targets, and as I say, in marked contrast to other court backlogs. So that's why I believe that the new Clause 30 isn't necessary, and it is properly considered to be a delaying tactic. Now, this is a bill, Madam Deputy Speaker, that the Conservative manifesto in 2019 promised would benefit tenants. Instead, this has become a bill where the balance too often is in favour of the landlords, particularly with the new Clause 30, which could indefinitely delay the abolition of Section 21 no-fault evictions. If that were so, that would be nothing short of a betrayal for the Conservative manifesto that was promised in 2019. And for that reason, I'm unable to support this today.
Munira Wilson.
Mr. Speaker, I'm delighted to be here speaking on this important legislation on behalf of my honourable friend, the member for North Shropshire, who's done a huge amount of work on this bill, including during committee, and I thank the Minister for his comments about her. Unfortunately, she couldn't be here, hence I'm standing in her place. But I would also like to acknowledge the constructive way the Minister has worked with my honourable friend throughout the passage of this bill on specific amendments, and I'll touch on some of those in due course. Liberal Democrats are supportive of the bill in principle because we want to ensure the private rental market is fair for all. We have long called for Section 21 no-fault evictions to be scrapped, and as a London MP, barely a week goes by when I don't hear from yet another family that is being turfed out of their home for spurious reasons under Section 21. But I'm sorry to say, as has been mentioned by many members already, this government has been far too slow in bringing forward these measures. They've been dragged kicking and screaming at every turn. And having made the commitment 5 years ago and had plenty of legislative time available in the last and current session, they've delayed and delayed. Meanwhile, a cost of living crisis has meant even more homeless people being made homeless, rising pressures on councils having to pay for emergency accommodation. Now, turning specifically to several amendments under consideration today, Amendment 3 has been tabled by my colleague, the Honourable Member for North Shropshire. This would increase the time which must elapse between a landlord taking ownership of a property and making the property available to rent to 6 months from the currently proposed 3. The 6-month period is designed to act as a more effective deterrent for landlords wishing to evict tenants to remarket a property quickly or flip it into a holiday let. Now, I note the opposition front bench has tabled a similar amendment with a proposal to extend the time to 12 months. Liberal Democrats believe this would risk driving landlords away from the market, and that 6 months strikes the right balance between protecting tenants from sharp practice and driving reputable landlords away. Flipping or quickly remarketing property for holiday letting has caused serious injustice in some of the most beautiful places in the country, such as Cumbria. Local people living in tourist hotspots often struggle to afford a home in their area because of the rapid increase in the number of properties taken out of residential let and used solely as short-term holiday lets, and this has a knock-on impact in terms of workforce pressures, particularly actually in the hospitality sector and the care sector. Of course, there does need to be some holiday accommodation in these beautiful areas which do benefit economically from attracting tourism, but we must find a balance of holiday and private rented sector accommodation. So I'm grateful to the government for accepting this point and working constructively with our benches in bringing forward Amendment 66. Now, while the government's Amendment 66 doesn't quite go as far as the Liberal Democrats would have liked and include a 6-month restricted period, It will ensure landlords cannot remarket a property as short-term or holiday let within 3 months of purchase. This takes a much-needed step forward towards levelling the playing field in the housing market for local people in tourist hotspots to help local economies and communities to thrive. Turning now, Madam Deputy Speaker, to Amendment 37, tabled by my honourable friend, the member for North Shropshire. This would ensure that accommodation rented from the Defence Infrastructure Organisation by service individuals and their families is subject to the Decent Homes Standards. Servicemen and women are housed in accommodation rented from the DIO, which currently is not subject to a minimum standard. This means that individuals who've put their lives on the line for our country are not necessarily guaranteed a warm and safe place to live in return. Across the country, and specifically at RAF Shawbury and Turnhill Barracks in North Shropshire, there have been reports of service family accommodation being plagued by black mould, rat infestations, and chronic overcrowding. This is no way to treat people who have put their lives on the line to serve this country, and frankly, they deserve better. Amendment 37 would ensure all accommodation rented from the DIO meets minimum housing standards, such as being in a reasonable state of repair and providing a reasonable degree of thermal comfort. Without this amendment, the government would miss out on a crucial opportunity finally to bring service accommodation up to a decent standard. I'm sure members on both sides of the House will agree with me that this is the absolute minimum we should be offering to service individuals. And so I hope that the Minister, when he winds up later on, can offer some reassurance from the dispatch box that he and his department are willing to move on this issue ahead of the bill moving to the other place, working with my honourable friend, the member for North Shropshire, to ensure that the Decent Home Standard is applied to all military service accommodation. Otherwise, we will be seeking to move this amendment to a vote. On Amendment 28, tabled by the opposition front bench, for those members opposite who are questioning why we should move to scrapping Section 21, not just in name, but implementing this legislation at the earliest possible opportunity, I asked them what they would say to the father in my constituency who contacted me last year, who was served a Section 21 notice for having the temerity to fix a leak in his home which was causing damp and mould. His landlord had refused to do the repairs, and he had 2 children living with very serious health conditions whose symptoms were being exacerbated by this mould. The endless delay from the benches opposite has meant that thousands more families, like my constituents, have found themselves homeless. And just this last week, I received another case of a family who are about to be evicted just as 2 of their children start their GCSEs and A-levels, respectively. 1.8 million renter households in this country include children. We should be putting them first, and this is why we will be supporting Amendment 28. Abolishing these sorts of evictions would also ensure that tenants living in properties suffering from disrepair or even infestation can report these issues to their landlords without the fear of a revenge eviction. This would also drive up standards in the rental sector and give tenants a much-needed voice. There should be absolutely no delay in the abolition of Section 21 notices. I would also like to speak in support of Amendment 20 brought forward by the opposition front bench, which would maintain the existing definition of antisocial behaviour as the conduct of causing or likely to cause a nuisance or annoyance, rather than defined as behaviour is capable of causing nuisance or annoyance. This is a small but critical difference in the definition of antisocial behaviour, and without this amendment, the Conservative government would be allowing a very ambiguous definition of antisocial behaviour to be written into the statute book. The government's definition of antisocial behaviour could allow landlords to use it as a quick way to evict tenants, or as a backdoor to Section 21 evictions. During committee stage, my honourable friend, the member for North Shropshire, did move an amendment which worded the definition similarly. We must have a definition of antisocial behaviour which protects tenants from unfair eviction, but also ensures that in cases of genuine disturbance, landlords have the tools necessary to evict tenants. And in his second reading speech, the Secretary of State promised to this House that this bill would bring tenants and landlords together to put in place stronger protections for the future. and without Amendment 20, he will fail to do so. On NC 38, tabled in my own name, this is a very technical change that I discussed earlier with the Minister, which seeks to address an anomaly in the bill, as previously drafted, in relation to leaseholders seeking to let their properties. Now, I'm very grateful to the Minister and his officials for their attention, and I recognise that NC 13 from the Government addresses this issue to a large extent, though, as discussed earlier with the Minister, I look forward to working with him and discussing with him further how we can ensure this provision is further extended to leases where freeholder or management company consent is required for a subletting. And I'd also like to place on record my strong support for new clause 12 in the name of the member for East Worthing and Shoreham. I strongly endorse all of his comments with regards to care leavers, foster families, and of course he would expect me to add to that families of kinship carers as well in that same category as well. And I urge the Government to work constructively with him on that point. So in conclusion, Madam Deputy Speaker, we the Liberal Democrats are broadly in favour of this bill and appreciate the Government has agreed to work with us on this, the importance of safeguarding communities from being priced out by the popularity of the holiday let market. Despite this, we would like to have seen the bill go further. So we urge the Government not to ignore this opportunity, finally to guarantee service individuals and their families the right to decent housing, to close the ambiguity around antisocial behaviour, and in order to ensure that it's not just another way for landlords to unfairly evict tenants. And I will end by calling once again for this Government to stop kicking the can of abolishing Section 21 down the road. I would say very gently to the Minister, because it's been very collaborative and it's in his comments, but I would say very gently. We've seen with the Rwanda bill that when the Government is hell-bent on doing something for political purposes, they will ram legislation through and they will ensure that those flights get off the ground because it serves their political purposes. So if there is a will, there is a way, because I take on board the point about the courts being ready, but I firmly believe if this Government does want to do something, it has the means to achieve it. And therefore I urge him again to protect renters, particularly those families with children up and down the country who are facing homelessness every single week. This is a core reform that Liberal Democrats have been long calling for, and the Government have long delayed. It's high time they stepped up and delivered it. Thank you.
Before I call the next honourable member, order. I have now to announce the result of today's deferred division. On the draft Economic Growth Regulatory Functions Amendment Order 2024, the ayes were 395, the noes were 50. So the ayes have it, the ayes have it. And now we proceed with the remaining stages of the Renters Reform Bill. Anthony Mangnall.
Madam Deputy Speaker, I rise to speak on the amendments in my name as well as a number of government amendments. And I feel I should start by actually thanking both the Minister and the Shadow Minister for their conversations over the last 5 months on this topic. And I should also be clear about my position in leading a number of amendments on this bill. At no point have we ever sought to stop Section 21 from coming in. In terms of it, and I hope I'll be able to make this clear in the course of my remarks, what we have sought to do is to stop the ending of fixed-term tenancies, something I believe will have a dramatic impact on the supply of properties and long-term rental properties. That, to me, is the concern, and that, to me, will cause far greater upset in the short and long term in ensuring that people can have the houses that they need. From the outset of this bill, delighted to.
I'm very grateful to my honourable friend, particularly in rural areas like mine, where the housing is already very expensive. What is going to happen, in fact, and has already been happening, is that more and more landlords will simply think that letting their properties out is not worth the candle. They'll sell them. The effect is there will be fewer and fewer properties to rent. Those that are available will therefore go up and up in price. And our youngsters will struggle then, therefore, to get onto the rental ladder.
The right honourable gentleman for the point that he makes, and it is one that I'm going to come on to, both in terms of the impact that this bill will have on short-term lets and the attractiveness of that, and indeed the bureaucracy and hassle that will arrive from the legislation that I think is being put forward in this bill. As I was saying, from the outset of this bill arriving in Parliament, I worked to try and ensure that the bill strikes the right balance between tenant and landlord, a balance that would ensure that the rights of tenants are respected and enshrined in legislation, while the rights of landlords, property ownership and contract law are maintained and safeguarded. Failure to strike that balance, I believe, will have a disastrous impact on the private rental market within the United Kingdom, complicating the rental market with onerous requests, bureaucratic measures, additional costs, and the inability to operate your own personal property as an individual might wish will only result in large swathes of the private rented sector throwing up their hands and selling their properties. Just as the same as failure to support tenants will only embolden rogue landlords, diminish standards and increase unfair treatment. It has been my mission from the start, Madam Deputy Speaker, to find a level playing field that ensures both tenant and landlord can cooperate together to provide a fair market that has a healthy supply of rental properties with rights and standards enshrined, with costs low, with bureaucracy minimal, and with a system that respects the rule of law, and perhaps most importantly, has a structure and a court system that is effective and delivers. All of this has been done because we are in the midst of a supply crisis within the private rented sector, something we have yet to touch on. There are an average of 25 prospective tenants inquiring about every available rental property, up from 8 in 2019, according to Rightmove. By the end of 2023, Hamptons estimates that individual landlords would have sold almost 300,000 more homes than they bought since 2016. Last year, the Bank of England warned demand for rental properties continue to outstrip supply as the number of landlords choosing to exit the market increased. It's therefore vital that this bill has the confidence of responsible landlords, that pragmatic changes are being made to the bill. Failure to do so is only going to deepen that crisis. Turning to the amendments, if I may. At the earlier stages, regarding Amendment 6, at the earlier stages of this bill, I remarked that failure to have a sensible period of rental at the start of a tenancy would likely result in the flourishing of long-term rental properties being used as short-term lets. Given the substantial price difference between short-term lets and long-term lets in constituencies such as mine, and indeed as the Honourable Lady has mentioned in Shropshire and in Northumberland, I believe, sorry, I'm going to get the former leader's constituency wrong, there would be a very real likelihood of people exploiting that loophole. Thank you, Cumbria, I apologise. Further to which, landlords incur costs and expenses when entering into a tenancy, and they need some level of certainty of a minimum period, coupled with the fact that many buy-to-let mortgage lenders also require a minimum 6-month tenancy agreement in order to lend to residential landlords. As a result, I tabled Amendment 6 with the support of 58 colleagues to ensure that tenants could not provide 2 months' notice to leave the property until they had resided in it for 4 months. This is in line, I believe, with the recommendations that were made by the Honourable Gentleman's Select Committee. I therefore welcome the fact that the government... can I just finish this point and then, of course, I'll give way? I therefore welcome the fact that the government has accepted this argument and introduced new Clause 15, which mirrors Amendment 6, and I will therefore withdraw my Amendment 6 of the Honourable Gentleman.
I wonder if I could just tease out from the Honourable Gentleman a bit of his reasoning as to why he thinks the possibility of rental properties being used as short-term lets is such a serious one. It's an entirely hypothetical problem. Renters taking out these tenancy agreements will have to provide 5 weeks of deposit. They'll probably be charged the maximum. They have to go through a lengthy process of trying to get those deposit backs. What evidence does he have to suggest that en masse tenants are going to try and game the system in the way that he expects?
Respect to the Honourable Gentleman, and I thank him for his interruption. I'm saying that is one of the reasons that I fear not having a minimum notice period. But I would also reflect in constituencies like mine, where we have the highest number of second homes and short-term lets of almost anywhere in the country, and there is such a significant price differential, and there is such a significant amount of hassle that is being heaped on landlords by this bill, that is the way in which it may push people, and that may be one of the foreseen consequences. offences. And I raised this at second reading and indeed have had private conversations with the honourable gentleman about it. As I say, Madam Deputy Speaker, I withdraw my Amendment 6. Regarding new clause 2, on rent repayment orders. This was a new clause that would enable local housing authorities to impose financial penalties on certain individuals when it believes a housing offence has been committed by a body corporate. Last year, the Supreme Court delivered a landmark ruling, and it said that where rent-to-rent companies take over the running of a property, they cannot pass their legal liabilities onto the landlord of the property. The government has amended the bill to reverse this decision. It would mean that landlords could be fined even in cases where rent-to-rent or other similar companies has, without the landlord's knowledge, been asked by tenants to illegally sublet a property. Again, according to data from Direct Line, 1 in 10 renters admit to subletting part of the home they currently live in, of which 48% did not disclose this to their landlords, and 3/4 did not review their existing lease agreements to determine if subletting was permitted before doing so. This amendment would deal with the main concern associated with the use of rent-to-rent companies. It would address the problem of landlords and others who willingly hide behind such companies to let properties while avoiding liability for rent repayment orders without penalising those who are innocent victims of such companies. Again, I welcome and recognise the fact that the government has seen sense to table their own amendment, mirroring my clause 2 in the form of new clause 34. And Madam Deputy Speaker, I therefore withdraw my new clause 2, if I am permitted to do so. Regarding Amendment 9 and 8, under my name on court reform, as has been discussed already, the amendment will require the Secretary of State to publish a review of the operation of residential possession proceedings before determining the commencement date for the provision of Chapter 1 of Part 1. Reforms to the justice system are, of course, vital for tenants and landlords to be able to enforce their rights when Section 21 is rightly ended. The Law Societies warn that courts are vastly overstretched. Possession claims and the eviction process can take many months, sometimes more. It continues. This bill may lead to an increase in contested hearings in the short term, as landlords that would previously have used no-fault provisions will instead have to prove fault. The government must outline how it intends to manage increased demands on court and what additional resourcing it will put in place to deal with existing backlogs. Again, data from the Ministry of Justice shows that it takes a mean average of almost 29 weeks between a private landlord making a legitimate possession claim and the repossession actually happening under Section 8 procedure. The Ministry of Justice notes that timeliness figures are higher than the legal guidelines, and it's not acceptable that where tenants are committing antisocial behaviour, fellow tenants and neighbours are expected to wait over half a year before the problem is resolved. Please.
Does he accept it? I said in my opening speech, we are exploring expediting possession for serious antisocial behaviour claims. I'm happy to work with him on how we get that and ensure that it happens before these reforms are fully implemented.
Minister's intervention, and I think he'll find this as the part of my speech where we'll be agreeing vehemently, and the latter part of the speech might not be so agreeable, but I thank him for that intervention, and I always welcome the opportunity to work with him on this. Likewise, in the case of rent arrears, it cannot be acceptable to have a system that allows rent arrears to continue to build for 7 months. The amendment under my name would make good on the government's commitment that the justice system is fully prepared for the impact of the end of Section 21 before it goes on. Again, I'm grateful to the government that it's decided to accept this point in principle and introduce Government New Clause 30, which mirrors my amendment supported by so many colleagues here, Amendment 9. So I therefore withdraw my Amendment 9. With regards to New Clause 1, the repeal of requirement for selective licensing, the new clause that I put under my name would remove the ability of local housing authorities to designate areas as subject to selective licensing. Now, the bill provides the Secretary of State with the power to develop a new property portal that all landlords would have to join to demonstrate to prospective tenants that the properties they rent meet all required standards. It would be effectively a national licensing scheme. As selective licensing deals with only management quality and not property standards, the changes in the bill are likely to do more than the selective licensing to improve properties. And since councils will be able to use the portal access, information on all private rented properties and landlords operating in their area, and in the view of plans for a decent home standard for the sector, local selective licensing schemes will be made redundant. In Wales, the introduction of landlord registration led to the ending of almost all selective licensing, and it is unlikely that local authorities would pursue costly and complex schemes in the future anyway. And I do take on board the comments the honourable gentleman made the Minister made in his opening remarks. Selective licensing is an additional cost to landlords, which will now be further added to the property portal and redress scheme, and they should not have to be regulated twice and pay twice for much the same thing. This amendment, my amendment, would scrap selective licensing for schemes for private rented housing when the property portal goes live. Having both would not enhance protections for tenants but merely be a duplication. Scrapping them would be an unnecessary layer of bureaucracy and a cost for landlords. But again, I am grateful for the opening remarks of the Minister, and I will take the government at its word on the dispatch box about conducting a review of selective licensing at its earliest opportunity. My new clause 3 around antisocial behaviour. This would be a clause that enables courts to consider hearsay evidence during the course of proceedings for possession on the grounds of antisocial behaviour. It is, of course, vital that when Section 21 ends, swift and effective action can be taken against those tenants committing antisocial behaviour who cause misery for so many neighbours and fellow tenants. To support this, the government has changed the wording in the discretionary grounds to repossess a property due to tenant antisocial behaviour under ground 14. It clarifies that any behaviour capable of causing nuisance or annoyance can lead to eviction. Previously, it was behaviour likely to cause a problem. However, in my mind, this is not the true problem. The problem currently, which is not dealt with by the bill, is that the main evidence of nuisance is proved by neighbours as they are the closest person involved. The changes to the definition of nuisance do not change the fact that evidence of behaviour needs to be provided, and that will still come from neighbours. They are, however, in so many instances reluctant to attend and give evidence, in part because of the slow speed of the court system will mean that they'll be forced to live near the person that they have helped evict for several months afterwards or reported. A better solution, in my mind, would be to allow landlords to use evidence of problematic behaviour that is provided by neighbours complaining by text or email to the landlord or their letting agency. This evidence is not currently admissible, and the courts cannot give sufficient weight to it when deciding if a tenant is committing antisocial behaviour. This amendment would allow for such evidence to be used by the courts. Now, in the negotiations and discussions that we had in the run-up to this moment, the Minister's Department and his civil service team were extremely helpful in highlighting the civil procedure rules, part 33.3, in relation to circumstance in which notice of intention to rely on hearsay evidence is not required. And again, the comments made by the Minister are somewhat welcome, although I hope his department will be able to follow up to the Department of Justice, and so I therefore withdraw new clause 3. Amendment 5 on houses of multiple occupancies relating specifically to students. This again was an amendment that the ground for possession for student properties could also be used for properties occupied just by 1 or 2 students, which would not otherwise have been considered as HMOs. Ending fixed-term tenancies would be problematic for the student housing market. It would be problematic for the whole bill, which operates on a yearly cycle for one academic year to another. Whilst the government has recognised this by allowing fixed-term agreements to continue in purpose-built student accommodation, it will not apply, as I understand it, to traditional off-street private rented housing, often rented to those in their 2nd or 3rd year of studies. This is a concern shared by much of the industry and indeed by the Honourable Gentleman's Select Committee, which noted currently the proposal is to include that this part of the PRS in the tenancy reform, but we conclude that abolishing fixed-term contracts here could make lettings to students considerably less attractive to private landlords, as the student market mirrors the academic year and benefits greatly from 12-month fixed tenancies. I hope I've quoted the Honourable Gentleman's report accurately. A government amendment to the bill, made at committee stages in the Commons, establishes a new ground for possessions, ground 4A, to protect the student housing market. This is to be welcomed. It will ensure that landlords can guarantee that most student properties will be available for each academic year. However, it will not protect all student housing. However, the new grounds will only cover houses of multiple occupation. It will not apply to the 2-person student properties and those lived in by a single student. This is an oversight that will be rectified with my proposed amendment, and again I thank the government for recognising this and introducing their own amendments in the form of 226 and 228, which have addressed that problem, and I am grateful. Madam Deputy Speaker, as I come to my concluding remarks at last, I would like to make some comment on Amendment 10 that was not selected, which is...
Order. I've been listening carefully to what the Honourable Gentleman has been saying, and he has a range of amendments, and it's perfectly in order for him to speak to those, but it's not in order for him to speak to Amendment 10, because it has not been selected. Not only not selected for a division, but it has not been selected for debate. There might well be a general point to which he could make reference, which might address a general point, but he may not speak to Amendment 10. Mr. Mangnall.
Speaker, for being so generous in your explanation on that, and I thank. The purpose and problems that I see with this bill is that while the intent to remove Section 21 is a good one, and it is a necessary one, and yes, it has taken time to get to this point, it is not one that those who have signed my amendments has ever objected to. The point and principle of why these amendments have been so widely supported is that there must be some leeway around ensuring that fixed-term tenancies can remain. Indeed, they still remain in certain instances within the student market. And that is... Yes, I will. Thank you.
He's made a very powerful speech. Does he agree with me that it's in renters' interest more than anything else to be able to agree longer-term tenancies than potentially just 6 months in order to have their own security of tenure? If you have a young family, you absolutely do not want some of those grounds, like sale, to come in the way of these things.
I thank the Honourable Gentleman for his intervention. He is absolutely right to make this point, because in its essence what this bill is doing, it is removing and forbidding a contract being agreed with a date at which point the tenant would have to leave the property. I might just also give reference to the comments of the noble Lord Hannanan of Kingsclere, who pointed out in February in this House, in the other place, that language matters in politics and tendentious phraseology has consequences. How is it that we have reached the point where the expiry of a contract freely entered into by two parties at the end of its term is now widely referred to as an eviction, let alone a no-fault eviction? To be clear, this bill is going to make it illegal to sign a fixed-term tenancy. And the lack of clarity when describing the end of a contract has meant that we are now terming simple cessations of contracts as no-fault evictions. Can I just finish a point, and of course I'll give way? Well, who is at fault when a previously agreed contract comes to an end at a future date? No one. I do believe that you can retain fixed-term tenancies and scrap Section 21, and that there are ways to go through in doing this. The Honourable Lady.
Grateful to him for giving way. I just wonder if he would concede the point that although in principle it is perfectly possible to imagine a scenario where the tenant and the landlord mutually agree to a new set length of tenancy, in actual fact the reality is exactly because so many tenants are rushing for so few properties, the amount of free will there is on the behalf of the tenant in signing up to that contract is actually not very much. And so this idea of it being mutually agreeable, I think, is rather more suspect than he suggests.
I actually come at that position from a different angle, which is that because we are heaping so many rules and regulations and making it so difficult, that people are leaving the market as a result. This was one of the pioneering policies of Thatcher that brought in the idea of the free market around property and ensured that millions of people across this country could play a social value in having a buy-to-let property on a long-term basis. Now, the Honourable Lady won't agree with me. I don't think we agree on very much. I'm okay, but it's good to be able to debate this, especially in this chamber. But I think we must be honest about this. The consequences of removing fixed-term tenancies is essentially the state turning around and saying to individuals what they can or cannot do with their own private properties. It does not give landlords... It is susceptible to remove Section 21 as well as retaining fixed-term tenancies. I have said, Mr. Deputy Speaker, that we have long prided ourselves on this side of the House as the party of free markets, and we should keep that in our minds when we vote later on today. It is... can I just finish this point, and then I'll give way? We are sending completely the wrong message, with dire consequences for future levels of housing supply. We are making an enormous mistake which will reduce long-term lets in favour of short-term lets and result in many properties being taken off the rental market. I would hate to be back here to have have to repeat the figures that I did at the start of my remarks, where in 2019 it was 8 people for every 1 property, and now it is 25, to say that that number is going up and up. But I fear that as a consequence of this bill, that is going to happen. The Honourable Gentleman.
Honourable Gentleman. He seems to be saying he's in favour of abolishing Section 21, but then giving landlords the right to bring in fixed-term tenancies, which end with a Section 21 notice. And if the landlord chooses, therefore, Section 21 won't be abolished, will it? It is something that will be a figment of our imagination here, because in practice it would never be delivered with his proposal.
That point, and he's absolutely right to make it, and he has far greater expertise in this area than I do. But I am saying you can retain fixed-term tenancies and you can scrap Section 21 and amend other parts of this bill. Breach of contract. Indeed, you could make notice periods longer. In fact, I know that the department even discussed this idea when this was mooted after the 2019 election, which was rather than you could scrap Section 21, but you could increase the notice period for an eviction. These are ways in which you could do it. But I think to throw the baby out with the bathwater and become so restrictive on someone's private property is a problem. People go into the buy-to-let market to let their property out. And unfortunately, I think the consequence again is that this will have the opposite impact. It will push people out of the market who will no longer want to deal with the hassle. Yes.
I thank my honourable friend for giving way. I think one of the challenges here, and he's making a fantastic speech, and I commend him for all of his efforts in relation to this bill, is that sometimes thinking about this is very constrained to, for example, a metropolitan area. We both represent rural constituencies really affected by short-term holiday lets. And the unintended consequence of this bill is that landlords will be pushed towards using them because the rules and regulations become quite so tight and constrained on long-term landlords. Does he not agree?
The Honourable Gentleman is absolutely right to raise that, and it comes back to this point of where we are in terms of trying to incentivise long-term lets over short-term lets. And again, in rural constituencies in the South West, we have faced this issue of the rising tide of short-term lets. However, we are not legislating today on the basis of our own respective constituencies, but the nationwide approach. And we should look very carefully at other countries and other examples of where things have gone so badly wrong by sometimes the simplest tinkering of housing legislation. Scotland on rent controls might be one. Finland or Berlin might be another. These are examples of where we have got things horribly wrong. And this, yes, of course I will.
Just listening very carefully to an excellent contribution, as always. They are lucky to have him in Totnes. Just further to the intervention from my honourable friend from the Cotswolds, is he saying then that the irony of this debate is that we are effectively legislating to no-fault evict tenants because we are pushing landlords out of the market by this legislation? And could he back that up with any more evidence that he's heard in the deliberations he's made in creating this excellent speech?
I understand that. Yes, I think he's absolutely right. What we have seen is, especially in, and I will use my constituency example, I have seen a significant decline in the number of long-term lets over the last 4-year period, going straight into short-term lets at a far greater cost as well, making it totally unaffordable and relying on us to have to come up with some pretty innovative ways of actually being able to supply the correct amount of rental properties for people who live and work in South Devon. And I think that is something reflected in East Devon and indeed out in Yeovil as well in Somerset and I'm sure in the Cotswolds. Mr Deputy Speaker, I will sum up, I will finish on the basis that I am grateful for the work the department has done on this. At no time do I think that the government has dragged its feet. At no time do I think that they have tried to block me. I have, by the nature of putting in quite so many amendments, I am probably responsible for some of that hold-up, and for that I apologise. But ultimately, this comes down to a belief in whether or not I think we are overreaching, and I feel that this bill is overreaching. There are ways in which we can help ensure the rights of tenants and landlords are enshrined and balanced, but ultimately removing fixed-term tenancies for me is a step that is too far and will be significantly negative for the future rental market. And I will unfortunately have to vote against the bill in third reading.
Thank you, Mr Deputy Speaker. The Renters Reform Bill had the potential to bring much-needed security and safety to renters. Yet amendments to water it down brought forward through the committee stage and even today are a backward step that will significantly undermine the bill's intent. As an MP with one of the largest student populations in the country, I'm all too aware that students are experiencing a housing crisis on top of a cost of living crisis. We have seen landlords asking student renters for guarantors as well as deposits of up to 100% of their annual rent. The criteria of which is that the guarantor must own a UK property. This impacts and hinders the accessibility for working class students of private rented sector accommodation at their university. Also impacts on care leavers or those estranged from their families accessing higher education completely, as well as international students who don't have family members with property in the UK. To mitigate this, I have put forward new clause 41 today that seeks to end one of the most illogical parts of the rental process, guarantor schemes. The expectation, despite entering a legal contract which outlines the responsibilities of the landlord and the tenant, a nominated individual takes responsibility for fulfilling the contract, seems to undermine the purpose of the contract itself. This amendment seeks to tackle financial pressure on students, supporting the member for Sheffield Central's amendment seeking to stop landlords from signing up tenants months before an academic year begins, which creates an arms race for student lets. We must also consider those from whom living at home has never been an option, have come through the care system or become estranged from their parents. Students do not know a guarantor owns a house in the UK. They must be stuck paying extra to private company, paying 6 months or more rent up front, or not being able to rent at all. Guarantors are not expected for most people of the same age who aren't students. So why is there this discrepancy for students? An international postgraduate student at Leeds University told me, my only viable option was using the guarantor service, Housing Hand, which cost me an additional £50 a month on top of rent and bills. I'm a PhD student receiving the UKRI minimum stipend, which is paid monthly. The cost of living for food and rent alone is already difficult on this stipend, and during the final week before the stipend is paid each month, I often struggle to maintain a healthy and balanced diet due to financial strain. This is not only demoralising, but affects my academic progress on a physical level, as I'm often hungry and unable to afford fresh fruit and vegetables, which are a staple of my diet. It may not sound like much, but not having to pay for this guarantor service can make a considerable difference to my overall well-being on a monthly basis, as this money can instead be used on fresh food. Research conducted by students from the Centre for Homelessness found that just 36% of universities provide help on rent guarantors, and even fewer provide a rent guarantor service for students. And as universities face financial issues themselves, this will become more unlikely. Renting as a student is already an uphill struggle. We know, for example, that student accommodation prices have increased by 61% since 2012, and information from NUS UK shows us that 2 in 5 students have considered dropping out due to the cost of rent and bills. When we're trying to encourage people to attend our worldly institutions that strengthen the skills potential of our country's workforce, why do we put up so many barriers? Our universities are the UK's strongest soft power. This is particularly the case for international students who are left with nothing but bad choices, finding a UK guarantor or paying 6 months or more rent up front to their landlord. One student recently relayed this to the APPG for students, saying, international students often face more challenges than home students. We have heard stories of students paying months of rent up front only to find out they've been scammed and the place they thought they'd secured doesn't even exist. We had one case where international students paid a whole year's rent in advance only to find out their landlord went bankrupt. While they eventually got their money back, the stress and uncertainty they went through was unbearable. The Renters Reform Bill was a welcome opportunity to rectify so many scandals in the private rented sector. Yet there had clearly been a continuing and concerted campaign to force the government to create an unprecedented 2-tier rental market where students were at the mercy of Section 21 evictions that other tenants would be protected from. Thank you.
Sir Neill.
Thank you very much, Mr Deputy Speaker. I should refer to my declaration in the Register of Interest as the owner of a single residential flat which is let out for those purposes. And I simply want to say in that regard that we always have to try and strike a balance in housing policy between the legitimate interests and rights of tenants and those of landlords as well, not of all of whom are large corporations by any manner of means, not all of whom make any great profit from those premises and often operate at quite small margins, but are a necessary part of the whole eco-structure. Equally, having served in local government for many years, I'm conscious of the pressure that unwarranted evictions can place upon families and then upon the local authorities who have to pick up their housing duty towards them. So I do believe the government is doing its level best within the bill to get the right balance as far as that overall picture is concerned. But I wanted to particularly speak to Government New Clause 30, if I might, Mr Deputy Speaker, because we've heard some rehearsal already as to the logic behind the amendment, the concerns as to whether or not this causes a delay to the abolition of Section 21 evictions, but equally concern about the pressures upon the County Court. And it's in that context, and wearing my hat as Chair of the Justice Select Committee, that I just wanted to flag up to the House the inquiry which the Justice Committee is currently undertaking and currently receiving evidence on in relation to the work of the County Court. I particularly welcomed the Minister's commitment of £11 million to be transferred to the Ministry of Justice to carry out the assessment. Because, of course, like local government and housing, the Ministry of Justice is an unprotected department. It is also a downstream department. It picks up through either the court service or other parts of its work many things that have gone elsewhere, wrong elsewhere in our public services or in society as a whole. And the court system, including the civil courts and the county court in particular, are very much a part of that symptom, if you like. They pick up a great deal of social problems that go through the county courts. And the county courts, on all the evidence that we are receiving, are under very great pressure. So I support the amendment, not because I want to delay the introduction of the reforms to the housing procedure that we're envisaged, not because I want to delay the abolition of Section 21 evictions as they currently stand. There may indeed, as my honourable friend for Totnes says, be other ways in which we can look at getting the balance, but not because I want to delay that reform, but because I do think we have to be frank and open about the pressure that potentially puts upon an already strained county court system. And if we are going to make those reforms, we then need to will the means, and that applies to both parties, to make sure that the county court works as efficient as it should do for parties, whichever side they are, be they landlords or tenants alike. And that's what I wanted just to refer to some of the evidence on. The overall picture of the some 43 published submissions that are already on the Justice Committee's website shows actually a very troubling situation as far as delays in the county court are concerned. There are delays in two areas that are germane to this debate. Firstly, in the time it takes to see a possession action through the courts itself, and then secondly around enforcement, and particularly in the delays in getting, where necessary, bailiff appointments and in the enforcement then carried out. There are real difficulties in both. They vary across the country, it is fair to say, but in many urban areas in particular, there is considerable pressure. In London and the South East, where my constituency is, that is particularly acute. Looking at what we've heard in those submissions, and although the majority came from landlords, they're based upon data which I think is accepted and verified, whichever way one looks at it. The large agents representation group's submission, they're an organisation that represents the largest letting and estate agents in London and the South East, have collected a deal of data. What they say is this, that on average the county court is taking approximately 276 working days to process a possession claim from initial inquiry to decision being given. Some of the other data that we get doesn't cover the whole of that process, and that's why it's important to have that, I think, overall picture. That's about 55 weeks on average, and that then doesn't include the enforcement time thereafter. That's unacceptable from both sides of the equation. So we need resources to put that right. Midland Heart, who are based in Birmingham, a housing association. So registered social landlords are well established. Registered social landlord said that typically possession claims may take a minimum of 8 months and sometimes 18 months to conclude. The Hyde Group, who are another major social housing provider, talked in terms of the current level of delays being extreme and unacceptable, I end quotes. And a number of those submissions also highlighted the serious delays in bailiffs executing warrants of possession when they are obtained under the current process. That, of course, isn't just unique to possession hearings. As has been observed, in some cases, possession hearings proceed with more speed than other parts of the county court process, but they're still painfully slow in many areas. For example, we've had pretty clear evidence that there has been an increase in possession actions of roughly 16% from the level for the equivalent quarter in 2019 before the pandemic. There was obviously a drop-off during the pandemic itself for a number of reasons. The county court has been observed, has done well to work to pick up the backlog that was created during the pandemic, and we ought to pay tribute to everybody in the county court, not just the judges, but also the staff, the office staff in the county courts, who worked phenomenally hard to try and turn that around. And if I might, Mr Deputy Speaker, I would just hope that all members in this House will try and find the time to visit their local county court and actually see the work that's done by people who, again, on the admin side, often not the best paid by any matter of means in the public sector. And indeed, recruitment and retention of staff in the county courts is itself a real challenge. All that means that we must have a continuing investment in the county court. And I hope the assessment that the Lord Chancellor carries out under the terms of new clause 30 will trigger help us to trigger that greater investment, will help to make the case for funding the county court much better than it has been for many years under governments, dare I say, of all political complexions. And to support that, I would simply refer to some of the words of the former Lord Chief Justice, Lord Burnett of Morden, who repeatedly told us when he gave his evidence on an annual basis to the Justice Committee that there are problems about recruiting full-time district judges, the condition of the estate, and very importantly, the fact that the county court relies almost entirely upon paper-based systems to carry out its work. The Crown Court has been substantially digitised. The High Court is substantially digitised. There is an ambitious digitisation programme that Her Majesty's Courts and Tribunal Service has, but it has run slowly, it has run behind its original intentions, and many of the proposed portals on the civil side are not yet in operation. So the net result is that we are working on an analogue system in the county court, which deals with about 95% of the civil claims and overwhelmingly the vast bulk of possession actions. To make this bill work, we're going to have to invest in the system that enables possession, where appropriate, to be dealt with the proper safeguards to tenants. Secondly, delays have been caused, and this is something that the government has to take on board, through the withdrawal of legal aid in relation to housing cases. Because repeatedly, when you talk to the Association of District Judges and others who gave evidence to us, because more and more people are appearing in person, and that's not just tenants in possession actions, very often it's those smaller landlords too who may not be able to afford the costs of a solicitor, hearings with litigants in person take much longer. They have to be explained more, the hearing takes longer, the judge has to draft up the orders which would normally be drafted by the lawyers, and therefore the productivity, particularly of the district judges who have to deal with those, is reduced. They can do with fewer cases in a sitting day. So that is another reason why we need that level of investment. To quote the Association of District Judges, their evidence to us was the county court has long been the poor relation of the justice system in relation to technology. The other problem is actually getting the district judges to do it, because there is a problem with the recruitment of salaried full-time district judges. They are the vast bulk of the people that carry out this work. It's an MOJ issue, and that does require making the working conditions, as much as anything, of those judges attractive and making sure that salaries are competitive. It's not the problem doesn't exist at the high levels of the judiciary. But unless you're going to have that, unless you're going to have proper representation in these actions so that actually time is saved by the lawyers honing down the issues and actually enabling the judges to deal with the cases more quickly, unless you've got sufficient judges being recruited to hear the cases, you're not going to achieve the much swifter resolution of these issues that the Act seeks to achieve. And finally, there is the issue of enforcement. Going back to the 2015, an interim review of the structure of civil courts led by Lord Justice Briggs, as he then was, described enforcement as the Achilles heel of the civil justice system, or at least of the county court. Now, it's fair to say that since 2016, the government has made serious investment in Her Majesty's Courts and Tribunal Services reform programme. There has been progress made, but it's fair to say this: the ambition that the Lord Chancellor set out of 2016 of transforming our justice system has not yet been achieved in the county court. So I hope that we can use this debate as a signal that if we're going to achieve the policy objectives, which I think broadly the House has essentially agreed upon, we've got to will the means to the court system, because you can't actually have efficient execution of policy without giving the means to the court system which carries it out. Legal rights, be they the rights of the tenant or of the landlord, are only as good as your ability to access the courts to uphold those rights in a timely fashion. And sadly, we're not yet able to achieve that. There are many great people doing work in housing law, be it in the courts, be it behind the scenes. And I just wanted finally, Mr Deputy Speaker, to say one of the great contributors to housing law in this country recently retired from the bench. His Honour Jan Luber, King's Counsel, may be known to some of you as one of the titans of housing law, both as a lawyer and then as a judge, and Jan recently retired as the designated civil judge for London, the person who had oversight of all London's county courts. He's done probably more for housing law than anyone else I've come across. But I hope in retirement he will speak frankly about the pressures his colleagues who are still working there are under. So that's my plea. If we want to make this bill work, we have to use the assessment of New Clause 30 as evidence for the need for sustained investment in our civil justice system.
Lucas.
Thank you very much, Mr Deputy Speaker. It is 4 months since the committee stage of this bill concluded and 5 years since the government promised to legislate for renters' rights. So I want to start by saying that I think it is totally unacceptable that the report stage of the Renters Reform Bill has been so long in coming, that it's deplorable for nearly 1 million renters to have been issued with Section 21 eviction notices in England since the government promised to abolish them, according to a recent YouGov data. Renters have been badly let down by this delay, and aspects of the legislation before us, I'm afraid, continues to let them down. Mr Deputy Speaker, my Amendment 12 would require energy performance certificates, EPCs, for properties to be provided to the database operator and for details to be recorded in the portal. This is a simple amendment, but it would make a big difference. It recognises that information is power, allowing tenants to know whether the home they're about to rent will be damp and leaky or warm and efficient. Amendment 12 also builds on the existing rules which require EPCs to be commissioned before properties are put on the market and for them to be clearly displayed in adverts in commercial media. Fairness and logic demand that renters are able to compare energy efficiency information when considering properties to rent, and that this should be an easy thing to do. A cold and damp home can end up costing them dearly, both in high energy bills and in health and well-being impacts. Renters in these kinds of cold, damp homes run an increased risk of problems associated with mould and of health conditions like asthma and heart disease, as well as poor mental health. We all know that the UK has some of the leakiest homes in Europe, and that tenants are particularly exposed to high global gas prices because the private rented sector is the least energy efficient of any tenure. A staggering quarter of renting households are living in fuel poverty today. So urgent action is essential to improve standards across the sector and to ensure that all renters have a warm and decent home in which to live. It therefore beggars belief, frankly, that last September the Prime Minister announced he was scrapping the requirement to upgrade energy efficiency standards in private rented properties to EPC-C. This was despite it being essential to deliver both on our climate and our fuel poverty targets. An upgrade, indeed, which would save tenants over £250 a year, even at so-called normal prices, according to the Climate Change Committee. So as well as harming renters, this regressive move was also contrary to the wishes of landlords, 80% of whom are in favour of stricter energy efficiency regulations. Turning to my Amendment 13, which seeks to tackle the crippling private rents that so many people are paying. In Brighton and Hove, in which my constituency of Brighton Pavilion rests, a new study of over 50,000 renters found that tenants in the city were spending a scandalous 56.9% of their pay on rent, making it the most expensive city to rent in England. Now, as this bill stands, the measures on rent increases are wholly inadequate. They rely on a resource-intensive and time-consuming appeals process that could even see tenants worse off at the end of it, because the tribunal would have the power to impose a higher rent than the one the tenant is appealing. This is frankly outrageous and goes directly against the promise that was made in the Secretary of State's white paper, which said, and I quote, "We will prevent the tribunal increasing rent beyond the amount landlords initially asked for when they proposed a rent increase." My Amendment 13 would simply make good this broken promise by ensuring the rent payable after a tribunal determination can be no higher than the rent initially imposed by the landlord in the notice served on the tenant. You would have thought that that would be pretty straightforward. Given that the landlord is proposing the rent level in the first place, this must surely be the upper limit of what the tribunal can determine. A principle the Secretary of State obviously does understand, since he put it in his own white paper. The removal of this commitment in the bill today before us shows us that the government is determined to bend over backwards to tip the balance of power even further in favour of landlords. In short, Amendment 13 would get rid of what seems to be a deliberate disincentive to discourage tenants from using the process that is supposed to protect them from unfair rent hikes. In the absence of a national system for rent controls with local flexibility, which is what I believe we really need, Amendment 13 is a modest rebalancing of the rent tribunal process, and I would welcome the Minister's consideration on this and his response when he sums up at the end of our debate. Mr Deputy Speaker, there is limited time, but I very much support the amendments that seek to prohibit evictions within 2 years of the beginning of a tenancy where the landlord wants to sell or move their family in. As the bill stands, tenants can be served 2 months' notice just 4 months after a tenant has moved in, making a mockery of ministerial claims to improve security of tenure. I also sincerely hope that ministers will accept Amendment 14, which addresses the deeply concerning fact that the notice period for eviction under the new landlord grounds is just 2 months. This amendment extends it to 4 months in recognition of the huge difficulty that many people have finding somewhere suitable and affordable to rent when they are evicted, which, as we know, is a major cause of homelessness.
Neil O'Brien. Thank you, Mr Deputy Speaker. I've never been a landlord, but I have been a private renter. And I really welcome some of the things in this bill, which would have helped me a lot and other private renters. When I was a private renter, I was offered some extraordinary properties. One I remember had dog mess all over the floor. Another one down in Elphicke Castle had bare wires hanging out the wall and a gas cooker barely hanging off of the wall. And so I really welcome the extension of the decent home standard to the private rented sector through this legislation. It's striking how little controversy there's been about that, given how big a deal it is. The proportion of private rented homes that have some sort of major Category 1 hazard in them has already come right down from 24% when we came to office in 2010 to just 12% now. But that is still too high, and it's 3 times higher than in the social rented sector. And so it's really great that today we'll be pressing on with fixing this. I think the government amendments that we're going to be debating today are really welcome. They bring us to, I think, a good balance between the interests of both tenants and landlords. So, for example, new clause 30, which makes commencement at the end of no-fault evictions dependent on having the county courts being ready. That seems sensible to me. The slow recovery of the courts from the COVID backlog has been very frustrating, and there is a much wider question about how we can get rid of old-fashioned practices in the courts which slow things down. And my right honourable friend, the chair of the Justice Select Committee, made some really important points about the paper-based nature of still a lot of what goes on there. But a lot of good ideas can be wrecked if you don't get the implementation just right. And the chair of the Justice Select Committee also mentioned that it takes about 55 weeks from commencement to possession at the moment, and that is much too long. although I do agree with what we are doing with the end of no-fault evictions, it is a big deal, and I think it is right and reasonable that those who let out properties do at least know that they can rely on a slick and well-functioning court process before we bring it in. Even the opposition front bench said that the courts were recovering rather than fully recovered from the pandemic, so I think they recognise that to a point as well. And the government have made a range of other sensible reforms in these new clauses in front of us to ensure that there is fairness for landlords as well as tenants here, including the new clause 15, which gives those who let out property some confidence in the first 6 months, the new student grounds as well, and I note that even landlord groups like the NRLA are now saying that we should get on with this legislation. So I think that's about right. There are a very large number of government amendments before us today, but I think the overall effect is to get us to a good balance in this legislation. I know that some do have concerns about the end of Section 21, but many other countries have a similar system where they don't have anything like that, and the sky has really not fallen in. Germany, Austria, Denmark, Switzerland and the Netherlands all ban no-fault evictions. They have a higher share of private renting than we do. In the US and Canada, states like California and Quebec do the same. The sky hasn't fallen in there. Even in Scotland, they've had it since 2017, and although they've done some other things that I think are pretty unwise in terms of rent control, even despite all that, the sky hasn't fallen in. And there are still a lot of reasons that landlords will be able to give to cite to make sure that they can get their property back. Indeed, my right honourable friend from Dover, who's not here, suggested that perhaps there were even still too many. But I do think it is essential that people can get their property back. The end of Section 21 just changes the balance a bit so that we recognise that it is no small thing to ask people to move homes. There are more people these days with children in the private rented sector, and it is hugely disruptive when you have to move. I remember in the place that I was renting, we were all moved out, and the landlord was supposedly going to do massive works to it. He ended up installing about one square metre of linoleum, and then he let it out again for the same rent. It was just a huge amount of disruption to no particular end. And for those who are in a more vulnerable position than I was, it's not a small thing to ask people to move home. And so again, by ending that, but still enabling landlords to get control of their property when they need it, that strikes, I think, the right balance. Now, these amendments today in the Commons, they're not the end of the story, and I felt a lot of sympathy for the comments made by the chair of the Housing Select Committee, who made some really important points, I thought, about estate regeneration in this bill. And I also had some sympathy for the Right Honourable Member for Twickenham, who made, I thought, some important points about defence estates and the like. So on the one hand, I understand the concerns of my honourable friend from Totnes on the one hand, but I also understand the concerns of other friends like the member for Dover, who worries it's too easy to evict people on the other hand. And I think it's not an easy thing to get the balance right, but in putting forward the suite of amendments, carefully judged amendments that the government has today, I think they've got the balance about right. This will make it fairer and more secure for people in the private rented sector, but it does also treat landlords fairly, and I think that's a fair balance.
Paul Blomfield.
Thank you very much indeed, Mr Deputy Speaker. I have to say, whilst respecting the views of the Right Honourable Member for Bromley and Chislehurst, and he raised some very valid points about the county court system and the pressures on it, nevertheless, as someone representing a very large number of private renters, I have to express my concerns and share those raised by the Shadow Minister and others about the failure of the government to deliver on its promise on no-fault evictions. But I rise as chair of the all-party group for students to comment specifically on the proposals in relation to students, to support New Clause 41, moved by my honourable friend member for Leeds North West, and to speak to Amendment 260, which is tabled in my name. Now, students form a very substantial part of the private rented sector, and the all-party group organised a meeting back in July to ensure their views were heard, and we brought together people from different nations of the UK and from all parts of the country. And I have to say that the Minister, who's sadly now not in his place, would have found it useful because it highlighted a number of issues in the bill which have not been properly thought through. Now, I have discussed the issues that came out of our meeting with the Minister, and I'm grateful for him having found that time. But I just wanted to share some reflections at this point in the bill's progress. First, on the decision to extend grounds for eviction from purpose-built student accommodation to houses in multiple occupation and potentially to other student renters, there are very mixed views across the country. Some are worried that exempting students makes them more attractive to less scrupulous landlords as potentially second-class tenants and less protected tenants. Others, though, were concerned that giving students the same protection as other renters would force landlords to leave the student market, a point that was made to them by landlords in areas where there was significant pressure on the housing market. But overall, we reached the same view as the Select Committee, that the exemption was probably on balance right, but it's something that needs to be kept under review. There is, though, a wider problem, and that's with the whole approach to students within the bill. And it seems that the government have approached students as a sort of one-size-fits-all model. They are 18 to 21, they are undergraduates, they are living away from the parental home for the first time, and they're living there during term time only. But students at our meeting were at pains to point out that they're not that sort of homogeneous group. There are mature students who are renting in their home city and needing to be there all the time. Students with families. There are many courses that don't start in September and aren't on this cycle around which the amendments the government's bringing forward to the bill are premised. There are postgraduate taught programmes on a different and longer cycle. There are postgraduate research students on full-time programmes over several years, like any other young professional. There are mixed households of students and non-students, and particularly where groups of friends form and maybe one member of the group graduates. Now, I discussed all these variations with the Minister, who I'm glad to see is back in the chamber, and his view was that any atypical student would simply not be subject to the exemption, partly because I think these issues haven't really been thought through properly. Now, that might be in their favour, but because it means that they've got greater protection. But it might leave them out in the cold because landlords will find them less attractive within the student market. And I think what that again emphasises is the need to keep the impact of these proposals in relation to students under close review. But if I could now, as the Minister resumes his seat, move to my amendment 260, which raises a further issue that the Minister referred to in terms of the cycle of student tenancies, and which I have discussed with him, and to which I think he was sympathetic. Now, it used to be, maybe when some of us were students, that undergraduates would start university in September, they would settle in, they would make friendship groups, and towards the end of the academic year, after Easter, they would start looking for accommodation for the subsequent year. Now, we've seen a landlord-driven arms race, as my honourable friend, the member for Leeds North West, referred to it, pressure forcing students ever earlier in the year to enter into contracts for the subsequent academic year. And we're now seeing, as a norm in many parts of the country, students who start a course in September, the following month being put under pressure from landlords to enter into a contract for the following year, forcing them at a point of their life at university when they've already got significant additional costs to pay a substantial deposit, but also forcing them into joint tenancies with groups of people who they discover later in the year are probably not the right group of people that they want to live with in the subsequent year, and appeals to landlords which are invariably rejected to step out of the contract into which they have entered. So, as the government is in its proposals regulating on the basis of this tenancy cycle, my proposition is that we should try to make that cycle work better by saying that for those contracts where we're designating as student contracts, they should not start sooner than March of the year in which students will take occupation in September. I think that will be in the interests of tenants for the reasons that all of those of us who represent students will know. But I think also by setting a defined starting point, it will end the arms race in the interests of landlords as well. I will.
Actually, the tendency that he's referring to is not new. My daughter, who graduated in 2011, therefore started in 2008, was already under that pressure. And he's absolutely right. For a lot of young people, that is an incredibly difficult situation to be in, to find a group of people they want to live with within a month of being at university and only starting the following year. So I think his proposals are very recommendable, and I wish him luck that the government is listening.
I thank the Honourable for her intervention, and it does vary from different parts of the country, but the way in which it has come earlier and earlier and earlier each year to the ludicrous position where students are being forced into contracts for the subsequent year almost at the moment that they start their first year is clearly something that needs to be addressed. And as I say, I discussed this with the Minister. When we talked about it, he seemed sympathetic. So I hope that it's an issue that we can address as the bill progresses.
Hobhouse.
Thank you, Mr. Deputy Speaker. And before I start my remarks, I want to refer honourable and right honourable members to my entry in the Register of Members' Interest. All my amendments 39 to 41, refer to the Protection from Eviction Act 1977, and I've raised this issue with the government for the last 2 years after one of my constituents, who's a lecturer in law at Bristol University, came to me with his concerns. And I raised it, and to be fair to the government, the honourable member for Kensington actually had a meeting with that group of academics. And then I heard nothing, which was a little bit disappointing. I have just this afternoon received a reply from the Minister, and I thank him for that, but it was dated yesterday and only sent to me today. So it is something that I will look very carefully at, but I still think it is important that I raise here what I have to say. So, Amendment 39, there are two parts to this amendment, which relates to the law on harassment of a residential occupier. At the moment, the law is complex and confusing, particularly for lay people, and difficult to enforce. I have just glanced over the response from the Minister, and the government currently believes that there is actually enough power of enforcement. As I understand it, the 1977 Act is actually quite unknown. Local authorities and the police don't know enough about it, and I wonder how we can work in that space to make sure that these unintended consequences that the new legislation will bring in will not allow rogue landlords or those who do not want to do the right thing to actually refer them to other pieces of legislation. Firstly, it changes the law so that everyone who is harassing a residential occupier to try and get them to move out of the property is subject to the same law. Currently, if a criminal landlord is harassing the tenant, the law is fairly clear. However, it might be another individual who is harassing the tenant to get them to move out. And in this case, the local authority have to try and find out if the person doing the harassing was an agent acting for the rogue landlord or not. There's also often deliberate obscurity about the identity of the landlord, and investigating the relationship between individuals to establish their precise legal relationship is time-consuming and unnecessary, where the aim of the legislation is to protect residential occupiers from harassment. This amendment changes the law to make enforcement easier for local authorities. The change will not affect the position of landlords. They will continue to be subject to the same law. It is only the local authority who can prosecute this offence, and they would still need to prove that a rogue landlord, their agent, or any other person knew or had reasonable cause to believe that their actions would have the result of causing the occupier to leave. The other thing that the amendment does is clarify the law. Currently, if a rogue landlord interferes with services which are reasonably required for the occupation of the premises as a household, this can constitute harassment. However, it is not clearly stated what these services are. And indeed, I think I can think of essential services like electricity or cutting the water off or whatever people can do, or even change the locks. Therefore, I think it is important that one actually takes into consideration what is there. And we're not talking about decent landlords. I think I've always made that very clear. It is getting to those landlords who are clearly not doing the right thing. However, it is not clearly stated what these services are. This amendment sets out a list of such services, including water, gas, electricity, and access to electronic communication networks and services as defined in Section 32 of the Communications Act 2003. Mr. Deputy Speaker, I now come to Amendment 40. There are three parts to this amendment. Firstly, at the moment, the law as to whether certain occupiers are protected by the law on illegal eviction is very complex and can be very difficult to establish. This is because some occupiers, for example, those who live with the landlord, are excluded from the protections in the law and so can be evicted without a notice or court order. This creates an incentive for sham arrangements where a rogue landlord might pretend to live with a tenant to circumvent the protections in the Protection from Eviction Act 1977. To deal with this clause reverses the burden of proof, placing it on the landlord to establish that an occupier is not protected by the law. It is based on the idea that everyone has the basic protections of the law, unless they are in an exclusionary category for good reasons, and the presumption should be that they are protected. Secondly, one of the biggest problems faced by residential occupiers and prosecutors is identifying the landlord. The current law encourages behaviour which obscures the identity of the landlord, and the bill does not address this. This new clause 4A amends the 1997 Act, so there is a rebuttable presumption in any action under the 1977 Act that the person the residential occupier pays rent to is the landlord of the property. The inclusion of other payments in respect of occupation of dwelling is taken from the wording in the Housing Act 2004. In relation to subsection 78, there are extensive complaints from local authorities and other that police ignorance of the law, and I've referred to that again, that the police ignorance of the law does not assist and at times obstruct the effective prosecution of offenders under the 1977 Act. The new clause amends the 1977 Act to require that if police become aware of potential offences of illegal eviction and harassment, they notify the relevant local authority. Further, it adds a power for police to assist the local authority in its investigation and prosecution of offences under the 1977 Act. Mr. Deputy Speaker, I now come to Amendment 45. This amendment seeks to amend the Housing and Planning Act 2016. This amendment would lower the standard of proof required for making a rent repayment or relating to illegal eviction or harassment. For other rent repayment applications, proving the offence is much more straightforward. For example, the landlord does not have a licence. Proving illegal eviction or harassment is much more challenging for applicants, and this difficulty means many applicants for the RRO for breach of the 1977 Act often fail. This amendment would bring the test into the line with the test used by the county courts to determine damages for illegal evictions or harassment. Now, all of this is pretty technical legal stuff that I have taken up because I really thought my constituent had a very fair point to raise. I will go very carefully to the response that the government and the minister has now sent to me and therefore seek to see whether I want to pursue this issue and see whether the amendment should be tabled in the other place. But I thank him for his answer. Thank you.
Thank you very much, Mr Deputy Speaker. I rise today to speak in support of new clause 40 on the order paper in my name. Before I do so, I'd like to make some brief remarks on the Renters Reform Bill more generally. Legislative reform of private renting is urgently needed. My constituency of Dulwich and West Norwood is in the eye of the storm of the housing crisis. Every year since 2010, the situation has worsened. The waiting list for a genuinely affordable social home has got longer, the number of people living in temporary accommodation has got higher, and private sector rents have continued to spiral. And this government has, despite many promises, delayed action for far too long. Private renters, housing campaigners, charities and members across this House are united in support for bold reform of private renting. But now, after years of delay, we see a government unable to deliver the effective and urgently needed reforms that were promised because they are too weak to face down their own backbenchers. At the heart of the matter is the urgent need for an end to Section 21 evictions. I have been calling for this since the debates on the Housing and Planning Act in 2016. Section 21 is the basis of insecurity in private renting because it gives landlords the ability to evict tenants for no reason at all. I have seen in my constituency time and again how Section 21 is used egregiously to ratchet up rents and to stop tenants from complaining about basic repairs or safety issues such as damp and mould. Because a Section 21 eviction does not need to be justified with a reason, all the power is in the hands of the landlords. Tenants literally live with the daily threat of the possibility that they will be told to leave their home, with all that this entails for having to find a new home when the costs of rent continue to rise. In a housing crisis characterised by an acute shortage of genuinely affordable social housing, private renting is a form of tenure upon which millions of people rely. They must have a degree of security so that they can put down roots, know that their children will be able to remain in the local school and live without the constant fear and insecurity that they may have to move. Section 21 is destabilising for families and for communities. It is therefore beyond disappointing that this bill will not result in an immediate end to Section 21 and that the Secretary of State cannot give a date by when it will end. And the reason for the delay is the shocking mess the government has made of the court system. My constituents, who used to be able to attend Lambeth County Court, now have to travel to Shoreditch after Lambeth County Court was closed in 2017. And when we were challenging the closure of Lambeth County Court on the grounds that it would involve a much more complicated and costly journey for constituents facing eviction who wished to attend court, we were promised digital reforms of the court service. We were promised investment in infrastructure in the courts to make the hearings accessible to anybody who had to attend the courts and to ease the complexity of the distance and the journey time being increased. And no such investment has been forthcoming. Lawyers, legal aid lawyers in my constituency who work in the courts speak of the chaos, they speak of the crumbling infrastructure, of the overburdened nature of the workload falling on the staff in the courts. And yet this is the excuse that we are seeing today for why Section 21 evictions cannot be brought to an end. Turning now, Mr Deputy Speaker, to new clause 40 in my name. Mr Deputy Speaker, this clause arises from a tragedy which happened to a family in my constituency. Their son, a first-year university student, had signed a tenancy on a house for his second year at university. His parents, in common with parents of university students across the country, were the guarantors for his tenancy. But before their son had finished his first year at university, and before the tenancy had even started, tragically, he died by suicide. Faced with one of the most terrible tragedies any of us could possibly imagine, these bereaved parents were then pursued by their late son's letting agent for the rent he would have owned on a tenancy he would never take up. I wrote to the letting agent several times on behalf of my constituents, but they refused to budge. A contract they maintained was a contract, and my constituents were liable as the guarantors, so they would just have to pay. Mr Deputy Speaker, surely in this House we can agree that a contractual provision which financially penalise bereaved parents for the suicide of their child is straightforwardly wrong. After I raised this case during PMQs, I was contacted by a number of families who had signed guarantor agreements with similar contracts, but also by a number of landlords and letting agents who said that they did not use such clauses in their tenancies and guarantor agreements. This demonstrates that such clauses are simply not necessary. Loss of rental income due to the death of a tenant is an insurable risk for landlords, and it should be a matter for insurance, not for bereaved guarantors. I am grateful to the Minister for meeting with me to discuss new clause 40, but I am baffled by the Government's response, which is to suggest limiting the obligations of a bereaved guarantor for 2 months, including during the proposed 6-month minimum commitment at the start of a new tenancy. While 2 months of rent is clearly preferable to 6 months or a year's worth of rent, 2 months is still, quite literally, a financial penalty for the death of a loved one. Bereavement is one of the hardest things anyone can experience. Government should use the powers at its disposal to provide comfort, security and peace of mind to the bereaved so that they can focus on grieving the loss of their loved one. It is simply not fair for bereaved guarantors to be charged for the rent that their loved one is no longer alive to pay. It is not necessary because the loss of rental income due to the death of a tenant is an insurable risk. New clause 40 would bring this practice to an end and give peace of mind to guarantors that should the unthinkable happen, they will not have to find hundreds or even thousands of pounds as they grieve. The Minister has said that he will continue to reflect on this issue. I urge him to do the right thing and to accept new clause 40 into the bill. It is a simple measure that will stop anyone else from experiencing the additional distress that my constituents suffered when their son passed away. This amendment has not been selected for a separate decision today, but I will be continuing to pursue this reform. It is the right thing to do. I urge the Government to look again at this issue. This is a reform which costs the Government nothing, but will give peace of mind to anybody facing bereavement, as my constituents have had to, that egregious landlords and letting agencies will not come after them for a cost that they may not be able to afford at a time when they need help, support and comfort and not additional financial penalties.
Minister, Jacob Young.
Thank you very much, Mr Deputy Speaker. I would like to start by thanking Right Honourable and Honourable members for their contributions during today's debate and for their ongoing engagement throughout the bill's passage so far. I will respond to some of the issues raised during the debate, although I may well not be able to respond to all of the points in the time that I have remaining. To start by addressing the points made by the Honourable Member for Greenwich and Woolwich and the amendments tabled by the opposition. As I outlined in my opening speech, I'd like to thank him and his front bench for their continued engagement and support for the bill. I believe we both share the same ambitions to see this bill on the statute book as soon as possible. New Clause 10 would extend Awab's law to the private rented sector. The tragic and avoidable death of 2-year-old Awab Ishak is the most shocking reminder of the danger of damp and mould. I'm clear that no tenant should have to live in dangerous housing conditions, but our approach to tackling this must reflect the differences between the social and the private rented sectors. Awab's law was designed for social housing. Most social landlords manage large portfolios and have dedicated repairs and maintenance teams, enabling them to tackle issues to specific timeframes. In contrast, the vast majority of private landlords own a small number of properties, with 82% of landlords having fewer than 5 properties and with 43% owning just 1. The bill takes a different and, I believe, more suitable approach to ensuring private tenants have safe homes. It gives councils powers to immediately fine private landlords up to £5,000 if their properties are dangerously unsafe. It also introduces a decent home standard for the first time and means a new means of redress through the Ombudsman. We'll also be publishing statutory guidance for councils on enforcement. We will explore how this guidance can strengthen the onus on private landlords to deal promptly with tenant complaints about hazards, including for larger institutional private landlords who may have resources much more similar to social landlords. Amendment 28, which the Honourable Gentleman spoke to, would remove Section 21 immediately upon royal assent. This would mean that there would be no transition period, as is currently planned, leaving no time at all for landlords, for letting agents, tenant groups or local authorities to adjust to the new system. And there would be no time to conclude the necessary secondary legislation, leaving the statute book a confusing mess. Importantly, without yet having the new possession grounds in place, this amendment would prevent landlords from being able to regain possession of their property, even where they have a legitimate reason to do so, which the new grounds reflect. Landlords could not repossess to sell or deal effectively with antisocial behaviour and repeat rent arrears. And most concerningly of all, temporary and supported accommodation would not have access to the critical new grounds in this bill. This would immediately have an impact on these sectors and clog them up. And so, although it might seem appealing and it sounds good, let's just abolish it at royal assent, this amendment would create chaos in the sector. It is far better for tenants and landlords alike if we make sure this change happens in an orderly way, and for these reasons I ask the Honourable Member to withdraw his amendment. Now, turning to the amendment from the Honourable Member for North Shropshire, given voice today by the Honourable Member for Twickenham. Amendment 37 seeks to bring accommodation provided by the Defence Infrastructure Organisation into the scope of the Decent Home Standard. I want to be clear that everyone deserves a safe and decent home, none more so than the heroes who serve in our armed forces. While 96% of service family accommodation already meets the Decent Home Standard, bringing such accommodation within the scope of the Decent Home Standard could provide a further safeguard to ensure that all service personnel and their families have the homes of the quality that they deserve. We therefore strongly agree with the intent of this amendment. There are, however, unique features of service family accommodation. This includes a significant portion that is located on secure military sites where there will be issues around security and access for inspections. This will create a challenge in how the Decent Home Standard is applied and enforced. The Government intends to ensure service accommodation meets the Decent Home Standard while recognising work is needed to determine the appropriate arrangements for monitoring and reporting, given the unique nature of this accommodation. My department, therefore, will work closely with the Ministry of Defence to explore these challenges and how we can best ensure that there are strong safeguards for service personnel and their families that work effectively in practice. And I can assure the Honourable Member for Twickenham and the Honourable Member for North Shropshire that we are seriously considering this issue, and the Minister for Defence Procurement and I intend to meet with the Honourable Member for North Shropshire to discuss these issues in more detail in the coming weeks before this bill is in committee in the Lords, and therefore I ask her to withdraw her amendment too. Turning to the Honourable Member for East Worthing and Shoreham's amendments New Clause 12 and 43 to 47, which would seek to extend core blanket brand provision in Chapter 3 to apply to care leavers. I'm most grateful to my honourable friend for raising the important issue of care-experienced young people's ability to rent homes in the private rented sector. The Government has already reserved a power in the bill to extend blanket ban provisions to additional cohorts in future should we find evidence that it's needed. This power could be used to extend the provisions to care-experienced people if evidence suggested that this would be effective. Helping care leavers to make a successful transition from independence from care to independence is a priority for this Government. And we recognise that care leavers can face significant barriers to securing and maintaining affordable housing, including providing a guarantor or rent in advance, which can lead to attaining a tenancy. We are already seeking to improve care leavers' access to housing, as set out in the Stable Homes Built on Love strategy, which sits alongside existing duties owed to care leavers by local councils as corporate parents. Furthermore, we understand at least 78 councils have passed motions granting care leavers the same protected characteristics status as other cohorts under the Equality Act in their local areas. And I'm happy to continue to work with my honourable friend to hear the challenges of care-experienced people face and how we can make private rented accommodation more accessible to them. Furthermore, I can confirm to my honourable friend that the measures to prohibit blanket bans on the basis that a child would live with or visit a person at a property include foster children, and to the Honourable Lady include kinship carers as well. Landlords and letting agents will not be able to discriminate against potential tenants on the basis that they foster children. No further legal provisions are needed to do this. More broadly, we're investing over £36 million this spending review in a foster carer programme and the foster carer recruitment and retention programme. This is the largest ever investment in fostering in England, and for this reason I ask the honourable member to withdraw his amendments also. Turning to my honourable friend, the member for Dover's amendments, New Clause 39 effectively requires landlords to compensate tenants when using any possession grounds found in Schedule 2 of this Act within 2 years other than grounds 7A or 14. While I appreciate the intent behind my honourable friend's amendment, I do not agree that landlords should be made to pay compensation to tenants when they have a legitimate reason to evict. Landlords looking to move into or sell their property or dealing with tenants in rent arrears may find themselves to be in financial difficulties too, and therefore this proposed change by this amendment could exacerbate this. Amendment 257 seeks to tighten the breach of tenancy ground so that a tenant can only be evicted if the tenancy breach impacts the well-being of the tenants or neighbours, or could cause material damage to the property beyond what would be covered by a tenancy deposit. As I've indicated to my honourable friend previously, I am sympathetic with the intention behind my honourable friend's amendment, and I think it could, but I think it could have some adverse consequences. For example, significant breaches of a tenancy agreement, such as subletting, may not lead to an eviction if they were proven to not have a material impact on other housemates or immediate neighbours. I'm also concerned about the impact it could have on existing contracts signed between landlord and tenant on the basis that this ground would be available. I'd like to reassure my honourable friend that ground 12 is discretionary, meaning a judge will consider whether the ground has been met and whether the possession is reasonable in each case. We therefore think it's unlikely that a tenant would be evicted for minor breaches, and I would seek to clarify that in guidance when this ground ought to be used. I'm also happy to explore what more could be done in legislation to ensure that tenants are not unfairly evicted for minor and unfair breaches within their tenancy agreement, and for those reasons I ask that she withdraws her amendments. Turning to the Honourable Lady for Dulwich and West Norwood and her amendment and the deeply moving case in her constituency, the tragic case in her constituency, and I was grateful to her for meeting with me yesterday to discuss it. New Clause 40 would prevent guarantors being held liable for the rent after a tenant's death. And as I've already indicated, this is an issue that the Honourable Lady has campaigned on for some time, and I appreciate her work on it. By moving to a system of periodic tenancies, tenants and their estates will no longer be locked in after the first 6 months. And in the event of a bereavement, the tenants' representatives would be able to serve 2 months' notice to end the tenancy and therefore end the guarantor's liability. Attempts to hold a guarantor liable for rent past the end of the tenancy would be a breach of the Tenant Fees Act 2019, and the landlord could be fined for doing so. I am aware that our new 6-month term may mean guarantors being held liable for longer. This is why we've committed to looking at the exemption that I discussed with her yesterday, where a tenant tragically dies, so that a notice can be served in the usual way. And for this reason, I ask the Honourable Lady to withdraw her amendments. Turning to the points made by my honourable friend for Totnes. In his own speech, he acknowledged that the government has accepted not one, but almost all of his amendments. I regret that he still feels opposed to the bill overall, but I hope listening to the debate and the changes, the significant changes we've made, he will reconsider his position. He mentioned Margaret Thatcher's reforms of the 1980s. Her reforms sought to smash a disastrous system of sitting tenants where landlords were blocked from moving into or selling their homes, or were being forced to let their properties below market rent. Our reforms build on hers. Landlords will still have a mandatory right to move into or sell their home, and nothing in our bill introduces rent caps, despite calls from opposition parties and the Mayor of London as well. Mr. Speaker, 5 years ago, Mr. Deputy Speaker, 5 years ago, the late James Brokenshire's Housing Secretary promised that we would abolish Section 21 evictions. 8 months later, every English member of this House stood on manifestos to abolish Section 21. In 2022, we published the white paper into how we would reform the tenancy system. In 2023, we brought forward this bill which gave the white paper legislative form. And today, we have an opportunity to move this bill forward, to back a bill which strikes the right balance between security for tenants and fairness for landlords. For tenants, this bill abolishes Section 21 evictions and moves to a more flexible system of periodic tenancies for all. It applies new decent home standards to the private rented sector for the first time and outlaws blanket bans on tenants with children and those on benefits, and gives renters a legal right to request a pet. It also expands the homelessness prevention duty to protect vulnerable changes. Together, these changes will give tenants the opportunity to put down roots in their communities, their children in local schools, and to live in a secure home. For landlords, this bill strengthens possession grounds, giving landlords certainty that they can get their property back, and provides stronger protections in cases of antisocial behaviour and repeated non-payment of rent, and protections for the student market and rural communities. Tenants will have to give 2 months' notice to leave a tenancy instead of 1, and we are making improvements to the court system to ensure that they can properly support the new system. The new private rented sector ombudsman will also help prevent issues escalating to the courts, offering quicker and cheaper resolution to disputes, and the new property portal will provide a one-stop shop for landlords to understand requirements and to demonstrate compliance. But above all, Mr. Deputy Speaker, this bill delivers for landlords and tenants because it drives out the bad actors in the system. That is what we aim to do, to build a sector that gives tenants security and protections and landlords fairness, not pitting one against the other, but working with both to drive out the bad actors. This bill is accumulation of years of work in a sector that has not seen meaningful change for 3 decades, and I ask all members to join with me and back the bill tonight.
Question is that Government New Clause 15 be read a second time. As many of that opinion say aye. Aye. Contrary, no. No. Division, clear the lobbies. The question is that Government New Clause 15 be read a second time. As many of that opinion say aye. Aye. Contrary, no. No. Tell us for the ayes. Joy Morrissey and Mark Jenkinson. Tellers for the noes, Colleen Fletcher and Christian Wakeford. Order.
The ayes to the right were 283. The noes to the left, 143.
Thank you. The ayes to the right were 283. The noes to the left were 143. So the ayes have it. Unlock. The question is that Government New Clause 15 be added to the bill. As many of that opinion say aye. Aye. Contrary, no. No. The ayes have it. The ayes have it. The question is that Government New Clause 30 be read a second time. As many of that opinion say aye. Aye. Contrary, no. No. Division, clear the lobbies.
Order. The question is that New Clause 30 be read a second time. As many of that opinion say aye. Aye. Of the contrary, no. No. Tellers for the ayes, Joy Morrissey, Mark Jenkinson. Tellers for the noes, Colin Fletcher, Christian Wakeford. Order. Order.
The ayes to the right, 287. The noes to the left, 144.
Thank you. The ayes to the right, 287. The noes to the left, 144. So the ayes have it. The ayes have it. Unlock. And just to assist the House, I'm not anticipating a vote for a little while as I now earn my money. The question is that new clause 30 be added to the bill. As many of that opinion say aye. Aye. Contrary, no. I think the ayes have it. The ayes have it. We now come to Government New Clause 13, and I call the Minister to move Government New Clause 13 formally.
Formally.
The question is that New Clause 13 be read a second time. As many of that opinion say aye. Aye. Contrary, no. I think the ayes have it. The ayes have it. The question is that New Clause 13 be added to the bill. As many of that opinion say aye. Aye. No. I think the ayes have it. The ayes have it. We now come to Government New Clause 14, and I call the Minister to move New Clause 14 formally. Wait for it. New Clause 14 formally.
Formally.
Question is that New Clause 14 be read a second time. As many of that opinion say aye. Aye. No, I think the ayes have it. The ayes have it. The question is that New Clause 14 be added to the bill. As many of that opinion say aye. Aye. No, I think the ayes have it. The ayes have it. Now come to New Clause 16. Call the Minister to move New Clause 16 formally.
Move formally.
Question is that New Clause 16 be read a second time. As many of that opinion say aye. Aye. No, I think the ayes have it. The ayes have it. Question is that New Clause 16 be added to the bill. As many of the opinions say aye. Aye. No, I think the ayes have it. The ayes have it. Now come to New Clause 17. Call the Minister to move formally. Question is that New Clause 17 be read a second time. As many of the opinions say aye. Aye. No, I think the ayes have it. The ayes have it. The question is that New Clause 17 be added to the bill. As many of the opinions say aye. No, I think the ayes have it. The ayes have it. We now come to Government New Clause 18. Call the Minister to move formally.
Move formally.
The question is that New Clause 18 be read a second time. As many of them say aye. Aye. No, I think the ayes have it. The ayes have it. The question is that New Clause 18 be added to the bill. As many of them say aye. Aye. No, I think the ayes have it. The ayes have it. We now come to Government New Clause 19. Call the Minister to move.
Formally.
The question is that New Clause 19 be read a second time. As many of them say aye. Aye. No, I think the ayes have it. The ayes have it. The question is that New Clause 19 be added to the bill. As many of them say aye. Aye. No, I think the ayes have it. The ayes have it. Now come to New Clause 20. Minister to move formally.
Move formally.
Question is New Clause 20 be read a second time. As many of them say aye. Aye. No, I think the ayes have it. The ayes have it. Question is that New Clause 20 be added to the bill. As many of them say aye. Aye. No, I think the ayes have it. The ayes have it. We now come to Government New Clause 21. Call the Minister to move formally.
Move formally.
Question is that New Clause 21 be read a second time. As many of them say aye. Aye. No, I think the ayes have it. The ayes have it. The question is that New Clause 21 be added to the bill. As many of them say aye. Aye. No, I think the ayes have it. The ayes have it. We now come to Government New Clause 22. Minister to move formally.
Formally.
Question is that New Clause 22 be read a second time. As many of them say aye. Aye. No, I think the ayes have it. The ayes have it. The question is that New Clause 22 be added to the bill. As many of the opponents say aye. Aye. No, I think the ayes have it. The ayes have it. We now come to Government New Clause 23. Minister to move formally.
Move formally.
Question is that New Clause 23 be read a second time. As many of them say aye. Aye. No, I think the ayes have it. The ayes have it. The question is that New Clause 23 be added to the bill. As many of them say aye. Aye. No, I think the ayes have it. The ayes have it. We now come to Government New Clause 24. Minister to move formally.
Move formally.
Question is that New Clause 24 be read a second time. As many of them say aye. Aye. No, I think the ayes have it. The ayes have it. The question is that New Clause 24 be added to the bill. As many of them say aye. Aye. No, I think the ayes have it. The ayes have it. We now come to Government New Clause 25, and I call the Minister to move formally.
Move formally.
Question is that New Clause 25 be read a second time. As many of them say aye. Aye. No, I think the ayes have it. The ayes have it. Question is that New Clause 25 be added to the bill. As many of them say aye. Aye. No, I think the ayes have it. The ayes have it. We now come to Government New Clause 26. Call the Minister to move formally.
Move formally.
Question is the new clause 26 be read a second time. As members say aye. As we know, I think the ayes have it. The ayes have it. The question is the new clause 26 be added to the bill. As members say aye. As we know, I think the ayes have it. The ayes have it. Minister to move new clause 27 formally.
Move formally.
Question is the new clause 27 be read a second time. As members say aye. As we know, I think the ayes have it. The ayes have it. Question is the new clause 27 be added to the bill. As members say aye. As we know, I think the ayes have it. The ayes have it. We now come to Government New Clause 28. Mr. Move.
Formally.
Question is the new Clause 28 be read a second time. As members say aye. As you know, I think the ayes have it. The ayes have it. Question is the new Clause 28 be added to the bill. As members say aye. As you know, I think the ayes have it. The ayes have it. New Clause 29. Formally.
Formally.
Question is the new Clause 29 be read a second time. As members say aye. As you know, I think the ayes have it. The ayes have it. Question is the new clause 29 be added to the bill. As members say aye. As we know, I think the ayes have it. The ayes have it. Number 31. Formally, Minister.
Formally.
Question is new clause 31 be read a second time. As members say aye. As we know, I think the ayes have it. The ayes have it. Question is that new clause 31 be read a second time. As members say aye. As we know, I think the ayes have it. The ayes have it. And I come to Government New Clause 32, and I call the Minister to move formally. Question is 32 be read a second time. As members say aye. As we know, I think the ayes have it. The ayes have it. Question is that new clause 32 be added to the bill. As members say aye. As we know, I think the ayes have it. The ayes have it. And I come to new clause 33, and I call the Minister to move Government New Clause 33 formally.
Move formally.
Question is that new clause 33 be read a second time. As many of them say aye. As you know, I think the ayes have it. Ayes have it. The question is that new clause 33 be added to the bill. As many of them say aye. As you know, I think the ayes have it. The ayes have it. We're now coming to the bit where we ask for new clause 34. Hang on. 35. 36. Be moved formally.
Formally.
Question is that new clauses 34, 35 and 36 be read a second time. As members say aye. I think the ayes have it. The ayes have it. Question is that new clause 34, 35, 36 be added to the bill. As members say aye. I think the ayes have it. The ayes have it. So, under the order of the House of the 23rd of October, I must now put the questions necessary to bring proceedings on consideration to a conclusion. We come to Government Amendments 200 to 205, 57, 56, 58, 59, 206, 207, 60, 208, 61, 209, 63, 210, 62, 211, 64 to 67, 212, 68 to 75, 213, 214, 195, 215 to 217, 76 to 80, 218 to 220, 81 to 113, 115 and 116. I call the Minister to move the amendments formally.
Move formally.
The question is the Government Amendments 200 to 205, 57, 56, 58, 59, 206, 207, 60, 208, 61, 209, 63, 210, 62, 211, 64 to 67, 212, 68 to 75, 213, 214, 195, 215 to 217, 76 to 80, 218 to 220, 81 to 113, 115 and 116 be made. As Madam Minister say aye. As we know, I think the ayes have it. The ayes have it. We come to Government motion to transfer clause 40. I call the Minister to move formally.
Formally.
Question is the Government motion to transfer clause 40 be made. As Madam Minister say aye. Contrary no. I think the ayes have it. The ayes have it. We now come to Government Amendments 117 to 137, 196, 138, 139, 197, 140 to 144, 221, 145, 146, 222 and 147 to 151. I call the Minister to move the amendments formally.
Move formally.
Got an easier job than I have. The government is that Government Amendments 117 to 137, 196, 138, 139, 197, 140 to 144, 221, 145, 146, 222, and 147 to 151 be made. As Madam say aye. Contrary no. I think the ayes have it. The ayes have it. Amendment 28, which you've all been waiting for, has been selected for a separate decision. I call Matthew Pennycook to move the amendment formally.
Move formally.
The question is that Amendment 28 be made. As many of that opinion say aye. Aye. The contrary, no. No. Division, clear the lobby. Order. The question is that Amendment 28 be made. As many of that opinion say aye. Aye. Contrary, no. No. Tell us for the ayes, Colin Fletcher, Christian Wakeford. Tell us for the noes, Joy Morrissey and Mark Jenkinson. Order. Order.
The ayes to the right, 158. The noes to the left, 282.
Thank you. The ayes to the right, 158. The noes to the left, 282. So the noes have it. The noes have it. Unlock. We now come to Government Amendments 152 to 157. I call the Minister to move formally.
Move.
The question is that Government Amendments 152 to 157 be made as amendments. Say aye.
Aye.
No, I think the ayes have it. The ayes have it. We come to Government New Schedule 1. I call the Minister to move New Schedule 1 formally.
Move formally.
The question is the New Schedule 1 be added to the bill. As many of that opinion say aye.
Aye.
No, I think the ayes have it. The ayes have it. We now come to Government Amendments 223 to 225, 158 to 161, 163, 164, 226 to 229, 165 to 174, 230, 175, 231 to 236, 176, 177, 237, 178 to 181, 238, 182 to 184, 245, 258. 246, 247, 198, 248, 253, 239, 240, 254, 259, 185, 241, 186, 242, 187, 199, 243, 188 to 192, 244 and 194. And I call the Minister to move the amendments formally.
I beg to move.
The question is the Government Amendments 223 to 225, 158 to 161, 163, 164, 226 to 229, 165 to 174, 230, 175, 231 to 236, 176, 177, 237, 178 to 181, 238, 182 to 184, 245, 258, 246, 247, 198, 248 to 253, 239, 240, 254, 259, 185, 241, 186, 242, 187, 199, 243, 188 to 192, 244 and 194 be made. Is another say aye? Aye. No, I think the ayes have it. The ayes have it. Consideration completed. Third reading.
Now.
King's consent. Minister to move third reading.
Thank you, Mr Deputy Speaker. I beg to move that the bill be now read a third time. This bill is an opportunity for us to improve the life chances of millions of private renters across the country, and I hope we've also given reassurance to the millions of good landlords who endeavour to provide homes for those who rely on the private rented sector. When this government set out its levelling up missions in 2022, and as the levelling up minister I feel this keenly, we made a clear commitment to halve the number of poor quality homes by 2030 to restore a sense of community, local pride and belonging, especially in those places where it has been lost. When housing is secure and safe, it is the launch pad for rich and fulfilled lives and gives people a place they're truly proud to call home. This bill marks the biggest change to the sector in over 30 years. Rightly, honourable members have pressed the government to make sure it strikes the right balance, improving the sector for all, whilst ensuring that no party is unduly burdened, either by cost or by process. I believe this bill now strikes that balance, and I'm proud to have taken it through as my first bill as a minister. I should note that taking over a bill 24 hours before committee started was an added excitement that I shan't forget. And once again, I would like to pay tribute to my predecessors, my honourable friends for Walsall North and for Redditch. And at this point, I invite the honourable lady from Brighton if she wants to make an intervention.
I'm grateful to him, so he will know that I was trying to intervene on him earlier when he was summing up, and all I wanted to ask him about was the point that I made in my initial intervention, which was about rent tribunals. In the original white paper, the government said it was going to prevent the tribunal increasing rent beyond the amount landlords initially asked for when they proposed a rent increase. Why has the government gone back on that? Why are they now envisaging a scenario where someone could go to a rent tribunal and actually end up with a higher rent than the one they're appealing? That is surely a massive disincentive.
I understand the honourable lady's concerns. Large rent increases shouldn't be used as a backdoor method of eviction, but it's also crucial that landlords should be able to increase rent in line with market levels to maintain investor confidence. We've listened to concerns, and we think it's fair that the tribunal is not limited when it's determining that market rent. This means the tribunal, as she said, has the full freedom to make full and fair decisions and can continue to determine the market rent of a property. I understand that she has concerns about that. I would say that it is important that actually all of our measures are proportionate and that we avoid the tribunal also becoming overly burdened by too many complaints to the tribunal, which is why I think this necessary safeguard is useful in that context. Okay.
He's being very generous, but it's not just me that's said that it shouldn't be the case that the rent could rise. The government's own white paper said that just a very short time ago, and I just wish he would particularly address the point about the disincentive. If you, as a tenant, know that by going to a tribunal you could end up with a higher rent than the one that you're appealing, surely that is going to be a massive disincentive to do it.
Completely accept the honourable lady's point. Obviously, in a number of areas, we've listened to the sector and moved on from the white paper. When it comes to that, her point is legitimate, but it is also the reason why the tribunal is able to set above the landlord's request and have a market rent, because we want to make sure that the tribunal isn't overly burdened with repeat requests to challenge rent increases where they're perfectly reasonable. I will give way.
The whole point of a tribunal is for the tribunal judge to set what he thinks is a fair market price. It might go up, it might go down, it might stay the same, but that's the whole point of the tribunal.
Speaker, I entirely agree with my honourable friend, and that is why we've set the tribunal in that way, and I'm grateful for him to make that point. Mr Deputy Speaker, as has just been witnessed, we've had contributions from all sides in this debate, and I would like to thank all members for their contributions during the passage of this bill. Members across this House have worked collaboratively and diligently on this bill to ensure this important piece of legislation becomes law. I would also like to put on record my thanks to all of my officials. I can't name them all, but a few are Leah, Guy, Steph and Ross, my private office and the clerks of the House, as well as members from across this House, notably the members from Northampton South and the member from Totnes for all of their work, and of course the Government's Whip's office. But above all, Mr Deputy Speaker, I would like to thank all of those groups that I have had the pleasure of meeting, as they represent the interests of both tenants and landlords across the wider sector. I hope that our colleagues in the other place will continue to take the same collaborative approach that we have in this House and pass this bill with the speed it now deserves to give certainty and security to landlords and tenants across the country.
And is that the bill be now read the third time? Matthew Pennycook.
Thank you, Mr Deputy Speaker. I start by thanking the clerks, the House staff and library specialists for facilitating our debates on the bill, along with all the experts and external organisations that have engaged extensively with us on it. I put on record my thanks to all those honourable members who contributed to our proceedings at all stages, particularly those who served on the Public Bill Committee. I especially want to thank my honourable friends, the members for Weaver Vale, Westminster North, North Tyneside, Mitcham and Morden and Brighton Kemptown for their forensic scrutiny of the bill's provisions and the considerable efforts they made to strengthen it as a whole. I offer also my sincere thanks to the Parliamentary Under-Secretary for the manner in which he has approached our exchanges on this important piece of legislation. In being handed this as his first bill to take through the House, the Minister has been given an unenviable task, to put it mildly, but he's borne his troubles with good grace, and I have very much appreciated the civil way he's engaged with me throughout, and also his efforts within the severe constraints he is no doubt operating within to make a number of small but sensible improvements to the bill. Lastly, Mr Deputy Speaker, can I put on record once again the thanks of these benches to all those who've campaigned tirelessly, in many cases over decades, for a reformed private rented sector. In particular, I want to thank all those organisations, particularly the 20 that make up the Renters Reform Coalition, that have joined Labour over recent months in urging the government to amend the bill so that it levels decisively the playing field between landlord and tenant. Mr Deputy Speaker, Labour has consistently argued that the case for fundamentally reforming the private rented sector is as watertight as they come. A state of affairs in which more than 11 million people in England, not just the young and the mobile, but many older people and families with children, live day in, day out with the knowledge that they could be uprooted from their home with little notice and minimal justification, and where a significant minority of them are forced to live in substandard properties for fear that a complaint would lead to an instant retaliatory eviction, is intolerable, and the sector should have been transformed a long time ago. The bill as introduced was a good starting point for the reform that is necessary, but ministers could and should have strengthened this legislation rather than progressively watering it down in a forlorn attempt to appease a minority of malcontents on the government benches. As a result of the government's unwillingness to face down that minority, the bill that we send to the other place today is not only far weaker than it need be, but in danger of being fatally compromised. We will not oppose the passage of the bill tonight because it is essential that it progresses, but we hope their noble lords address that danger and that over the coming months we can convince the government to think again and ensure this long overdue piece of legislation truly delivers for renters.
Mr Deputy Speaker, it's a great tribute, I think, to my honourable friend the Minister that he's got the bill in a form which is far better than it was at second reading, and it's so much improved that there's not going to be a division on third reading. But that doesn't mean that everybody on these benches is satisfied with all the content of the bill, although albeit it is significantly improved. I recall, Mr Deputy Speaker, the enthusiasm with which the Conservative benches greeted the third reading of the Housing Bill in 1988. That is the bill which is being substantially amended by tonight's proceedings. And that bill was a fundamental supply-side reform. It was at the heart of the Thatcher revolution, which transformed the private rented sector from one where nobody wanted to engage and which was shrinking, and where young barristers like myself at that stage were making a living trying to defend the interests of landlords who'd found themselves haplessly on the wrong end of that legislation. We've moved a long way since then, and one of the essential elements of the 88 legislation was the short hold. The short hold was a privately arranged agreement between a landlord and a tenant that for a period the tenant would be able to have exclusive possession of a property rented by a landlord. During that period, neither the landlord nor the tenant would be able to renege on that agreement. The rent would remain the same. The landlord wouldn't be able to say, oh, I need to get repossession of that property for any reason at all. And that short hold principle is one which it seems to me is still missing from this bill. There was an amendment which would have brought back something like a short hold provision in this bill so that there was privity of contract between a landlord and a tenant who wished to enter into an agreement in relation to their property, in the same way as you can agree with somebody to rent a car or a caravan. And that principle of privity of contract, which is fundamental, I think, to Conservative beliefs, that was enshrined in an amendment which was deemed to be a wrecking amendment. I hope, Mr Deputy Speaker, that that amendment, which was signed by over 50 colleagues, will be resurrected in the other place where the rules are different, and that the principles enunciated in that will be able to be taken forward, and that the bill will be able to be further improved in the other place, because we need to ensure that we support Conservative legislation. We need to ensure that we support legislation which is designed to increase the size of the rented sector rather than shrink the private rented sector. And what I fear is going to be the inevitable consequence of this, and we've already seen a bit of that in Scotland, is that because this bill is going to reduce the supply of private rented accommodation, the cost of private rented accommodation is going to go up faster than the rate of inflation, and then the same sort of people who've been campaigning in the alliance to which the honourable gentleman opposite was referring, they will be saying, stop there, we must have some rent controls. And price controls over rents, because one set of regulations creates another set of regulations. And then we will be back to where we were back in 1977. And that consequence, it seems to me, is likely to follow and flow from what we are approving tonight. And I just hope that it will be able to be amended in their Lordship's House so that the supply side reforms, which are so fundamental in the 88 legislation, will be able to be carried forward, and we will be able to give fresh confidence to people who are thinking about entering the private rented market, or give them fresh confidence not to withdraw from the market as they are doing at the moment in increasing numbers, because it's not helping any of our constituents who are trying to get rented accommodation if that rented accommodation continues to escalate in price as it is at the moment. So I hope that if there is going to be a response to this very short debate, we'll be able to have a guarantee that under no Conservative government will we ever have any system of rent controls, and that I hope that the government will be able to assure us that the consequence of this legislation is that we will be able to increase the size of the private rented sector rather than diminish it further. Mr. Deputy Speaker, may I conclude by congratulating my honourable friend for Totnes on having waged not a one-man campaign, because behind the scenes there was a very large cohort of people who were very supportive of his amendments, and as a result of those amendments the bill has been improved significantly. One of his amendments, which wasn't selected, that's still in my view unfinished business, but we shouldn't shirk from congratulating my honourable friend for having carried this campaign forward so effectively and successfully, and we hope that when this bill comes back from the other place, and maybe it will take another year and a half like it is since it was first presented, and that may be the other side of a general election. Some of us may hope that it will be better if we don't have this bill on the statute book by the time of the general election, but that's another story. I won't go into that now. But whenever the bill comes back, I hope it will be in an improved form, and even more of the amendments supported on this side, put forward by my honourable friend for Totnes, will be included in the text of the legislation.
With leave of the House, Minister.
Just to confirm to my honourable friend that we do not intend to introduce any sort of rent controls.
It is that the bill be now read the third time. Members say aye. Aye. No, I think the ayes have it. The ayes have it. 7 o'clock motion, Minister, to move formally.
To move.
Question is on the order papers. Members say aye. Aye. No, I think the ayes have it. The ayes.